The date.
Learned counsel, Miss R. Chaudhary, with the consent of the other side, has prayed for adjournment, list the matter of 23rd June. Okay.
I have another interim order passed in IA number 221024 may continue below.
2210 लिखिबा दे
221021.
interim order passed. I interim order passed shall continue till the next date fixed. Or 2210 बाकी ना था.
Whereas in respect of item number 49, and then may I pray for adjournment on that maybe fixed on 23rd, 40 to 23rd this year, no?
23rd June.
Same matter. When I am for this time, I am for that.
Okay. Learned counsel, Mr. Ashok,
AK.
Mr.
AK.
Okay. A.K. Hussain has prayed for adjournment, list the matter on same day, 23rd June.
23rd of June. Hello.
My pleasure, Lordship. Item number 12. Pass over for Delos.
Learned counsel, Mr.
N. Ahmed.
N. Ahmed has prayed for adjournment, list the matter on after 1 week.
May it please your Lordship. Lordship, I beg to mention item number 46, Lordship. In this case, Lordship, my name has not been shown in the Lordship cause list, Lordship. And moreover, Lordship, I am on interim, Lordship. And the service is not completed yet, Lordship. It's an appeal against conviction. In IA case, Lordship, appeal has been, the sentence party is already suspended. But the case was fixed today, Lordship. May I pray, Lordship, let the interim may continue, Lordship, and after Lordship, the service complete, let it be listed, Lordship.
Respondent number 2.
I am for the appellant, Lordship.
POXO case.
Yes.
Learned counsel, Mr. B. Chaudhary.
It's not a POXO, 354A and 354, Lord.
Has submitted that his name is not reflected in the cause list. Post of registry to reflect his the name of learned counsel, Mr. B. Chaudhary, in the cause list as engaged counsel for the applicant. Engaged counsel, no?
Yes, Lordship.
Service report on respondent number 2 is awaited.
Yes.
Is the matter when do you want?
Lordship, it's for appeal against a conviction, Lordship. So, after Lordship coming up, the LCR is there, Lordship.
LCR is any?
LCR.
Meanwhile, also call for the LCR. List the matter after 2 weeks.
It can be, Lordship, after receiving of the LCR because Lordship is statutory appeal, Lordship.
LCR. List the matter after receipt of LCR.
Lordship, the interim Lordship in IA Lordship 391 Lordship, that may be continued, Lordship, because I already suspended Lordship sentence. But case is fixed today. Only that part is there, Lordship. It may continue, Lordship.
46.
Yes, Lord.
So, after receipt of LCR or after?
Yeah, after receipt of the
service report.
LCR, Lordship, it's a statutory appeal, Lordship. 2 years imprisonment.
Service report.
That was awaited, Lordship.
So, what to do?
Now,
After receipt of LCR or after service report?
after receipt of the LCR, Lordship.
Then
So,
what-
as well as service
as
report.
on the report of service of notice.
The interim may continue, Lordship, in IA 391, Lordship.
I here from 391. There's nothing, this has been.
But there is only 66 is there, Lordship.
Huh?
It's the last part.
6, okay. To remain on previous bail, why?
Yes. But the case
What?
is fixed.
There's nothing to continue. You're already in the.
Yes, Lord.
Required to be continued.
Yes.
We'll dispose of it.
Yes.
Finally together. Like.
Highly obliged.
May please, Lordship. As I beg to mention item number 36, Lordship. Can you pass over the matter, my lord? CDS call for
36.
36.
Learned counsel, Mr.
S. Rahman.
S. Rahman has,
On-
on behalf of learned
SM
counsel, Mr.
SM.
SM Abdullah P has prayed for adjournment. CD is not received. Call for the CD. Interim order shall remain in force till release the matter on 25th June.
Please, my lord. My lord, I am praying for adjournment in item number 33, my lord. This is a partnered matter. However, the engaged counsel, Mr. A.M. Khan, could not personally present today, my lord.
Okay, learned counsel, Mr. Oh. Uh, so these are tag matters. We'll have to, uh, কেটা আছে এতিয়া? We'll take it up with 33, 34, 35.
My lord, I am praying for adjournment in 33, my lord. Any date after 9th, my lord.
এইটো বেলেগ কৈ দিয়ক তেতিয়াহ'লে। বাকী দুটা থাকক। এইকেইটা থাকক। এইকেইটা থাকক। এইটো বেলেগ কৈ দিয়ক, কোন হয়? বেল মেটাৰ হয় কোন? Learned Counsel, Mr.
R. Thadani, my lord.
R.
Thadani, Thadani. I will just write it down.
Thakani, no?
Thadani, my lord. Thadani.
Has on behalf of Learned Counsel, Mr.
A.M. Khan.
A.M. Khan has prayed for adjournment. List the matter when you want.
After 9, my lord, any day.
10 June.
10 June. Deeply obliged.
May it please your lordship, with the consent of other side, I beg to mention item number 39, lordship. Lordship, the matter may be adjourned for the day, lordship.
Orders
Yes, lordship. There is IA for stay, lordship.
for bail, stay.
Stay, lordship.
Okay, Learned Counsel, Mr.
A Singh, lordship, for the appellant.
A. Singh. For R.K. Bhuiya.
Yes, lordship. On behalf of R.K.
Learned
Bhuiya.
Counsel, Mr. R.K. Bhuiya has prayed for adjournment. Have you taken the permission from the other
Yes,
side?
consent has been taken,
With
lordship.
the consent of the other side, has prayed for adjournment. List the matter when do you want?
Lordship, on 9th, lordship, because the executing court has proceeded the execution proceeding, lordship.
On
Early date may-
9th, on
9th.
9th.
Obliged, lordship.
May I
Thank
please
you.
your lordship? Lordship, I beg to mention item number 34 and 35.
Mm.
Lordship, my senior Mr. H.R. Chaudhary left Guwahati yesterday for Eid. So kindly matter may be listed on 10/6 as both the petitioners have been in custody.
10-6 দিছিলো নেকি? Okay. 34, 35, Learned Counsel, Miss, what is your name?
G. Talukdar.
G. Talukdar on, okay, নামটো আছে. Has prayed for adjournment. List the matter on 10-6.
Subject.
Wait, please, your
Oh.
lordship. Lordship, I seek your permission to just amend one annexure, my lord, in item number 6, my lord. It's not a correction. Just that annexure 3 and annexure 5, both the FIRs, while stitching, my lord, inadvertently, it has been mistaken. So may I just correct it, my lord, rectify it? 3 and 5 are interchanged, my lord, while stitching. Both are FIRs. 5 is actually annexed as 3. 3 has been annexed as 5, my
This is the
lord.
work of registry.
Okay.
Can you do it? I don't know.
Because, my lord, there is no error for clarification, my lord. Otherwise, it is correct. If lordship would just see it before permitting, my lord. Thus, the annexure 3 has been stitched at 5 and 5 is at 3, my lord. We just interchange the annexures, my lord.
কৈ দিব পাৰি থাকে।
No addition, no changing, nothing, my lord.
তুমি অলপ চাই দিবা।
Yes, we'll do it in front of the land court. Deeply obliged, my lord. So we'll just rectify it and matter, my lord, lordship. If not today, then lordship will take it up on Tuesday, my lord. Matter. We'll just do it because right
It's
now.
up to you. You want.
Lordship, then matter, I would prefer to do it on Tuesday if convenient for the
Okay,
honorable
okay.
court.
On Wednesday.
11th? Yes, my lord.
Which are the items you're referring to? 6. Only
Six,
one.
my lord. Only one item, my lord. Yes, Dr. Manoj Devna.
Learned Counsel, Mr. D.K.
DK
Bodham
Boydam, my lord.
has prayed for adjournment. List the matter on 11-6.
Obliged, my lord.
May I
Deeply
please,
obliged.
Your
my lord.
Lordship? I beg to mention item number 22, Lordship. With consent of the other side, matter may be listed after 2 weeks. 22, Lord.
Learned Counsel, Mr.
M.K. Dev.
M.
M.K. Dev.
On behalf of
As Varali.
Learned Counsel, Mr. S. Burali, with the consent of the other side, has prayed for adjournment. List the matter on
After 2 weeks, Lord.
after 2 weeks.
Only-
Please, your lordship. Lordship, I beg to mention item number 37, lordship. Kindly pass over for the day, lordship.
Learned Counsel, Miss, what is your name?
N.A. Begum, lordship.
N.A. Begum has
I'm
prayed
on
for
interim
adjournment.
notice.
List the matter on interim date. You're on
Interim-
interim.
Yes, sir.
Interim order shall remain in force till then.
Obliged.
May I please, your lordship? So I beg to mention this revision matter for withdrawal on with 11th of
You'll have to mention the court number.
May I please your lordship, I beg to mention
Revision
item.
withdrawal.
Yes, withdrawal of it.
Revision cannot be withdrawn, no? Cannot be withdrawn. It has to be decided on merits. If somebody has passed away, then it's okay. There's a settlement, it's okay, but
Actually, it is arising out of domestic
you
violence
can
case.
mention it before. Okay, okay.
Domestic violence amicably.
Mention it before. That is good enough.
May I
Mention
please
it.
your lordship, I beg to mention item number 43, my lord. I have checked office log, my lord. The service has not been completed. Can be on 11, my lord.
43.
43, my lord. Yes.
Lord Counsel Mr. G. Bora, no? D. Bora.
D. Bora.
On behalf of 43.
Yeah, 43, my lord.
Your name is not in the.
Yeah, yeah. My name is there, my lord.
Okay, okay.
In the downside, my lord.
Has prayed for adjournment.
Can be on 11, my lord.
Can we-
11, yes.
This is the matter on 11.
Yes. May I please your lordship.
একটু হিয়ারিং ডে হয় না অর্ডার্স ঠিক আছে
May I please your lordship.
It's for orders, it's
May I please your lordship. With regard to item number 54, lordship. With regard to item number 54, lordship.
Hmm.
I prefer upgradation of the item, same item, lordship.
আপগ্রেডেশন
Upgrade.
আসেনি আজ দুপুরিয়া দুটা পর্যন্ত
Lordship, having certain difficulty tomorrow on topic
54
54.
as
Can it be taken before 12? I-
supplementary list on
It's daily list, lordship.
okay
Lordship, can it be taken before 12, lordship? Because I have certain urgency regarding, because on the occasion of
before 12
before 12.
can be taken
Much obliged, lordship.
My lord, I beg to mention item number 29.
Hmm.
My lord, with the consent of the other party, we are begging for an adjournment today.
Hmm.
That the court may fix the matter after a week if it is a convenience of the court.
Please, Your Honor. I am appearing for a respondent in this case. My learned client has sent an order of the learned session judge
Hmm.
whereby maintenance was directed to be paid. Maintenance, interim maintenance. Any another proceeding, Your Lordship, there is a direction from this honorable court that the respondent shall continue to pay the maintenance to the respondent. So conflicting order may be passed, Lordship, so both the cases may be tagged.
okay which one along with which cases
Petition 73.
Okay. Learned Counsel Mr. H. Burwa is present for not H.
My lord, he is not present today. Personal
What
difficulties
is the
is
name?
use here, my lord.
Learned Counsel U. Suikya, Vice Learned Counsel Mr. H. Burwa has paid for adjournment. Learned Counsel Mr. G.R.A. Mutaki is present for the respondent number 2. List this matter along with
Criminal petition 73 of the 25.
after 2 weeks.
Bless you.
May I please your lordship. Lordship, I beg to mention one regular bail application for withdrawal, lordship, on money.
You'll have to mention before court number 11.
11 is not sitting today, lordship. Not sitting, and lordship, the matter has been referred to lordship. My lord,
কোন কোর্টের double এই বলো? Try court number 21. I cannot allow. Try court number 21. If 11 is not sitting today, try court number 21.
otherwise lordship is senior bench.
No, I cannot. I have not, I'm taking up appeal and criminal petition and then civil cases.
High level.
May it please your lordship, with respect to item number 1 and 2, the lordship, I am led by Mr. K. N. Chaudhary, senior advocate, your lordship. He is legs on some other court, your lordship. May kindly pass over the matter for a time being. Deeply, yes.
May I please your lordship? Lordship, I have corrected the first title, my lord, that was.
I forgot.
But here, my lord, the petitioner, he has been, my lord, convicted under section 17 of the, my lord, IPC, my lord, and sentenced him to undergo a rigorous imprisonment for 1 year and pay a fine of rupees 10,000, my lord. And in default, my lord, simple imprisonment for 3 months. My lord, challenging that, my lord, he has filed an appeal before the learned session judge, my lord, and learned session judge also appealed that order passed by the, my lord, learned CJM court, my lord. So that now we are against that, my lord, before your lordship.
Criminal revision?
Criminal revision. The IA has been filed, my lord, for this, my lord, for suspension of the sentence and for allowing the petitioner to, my lord, remain on previous bail, my lord.
It's 1 year, no? 2
1
years.
1 year.
417,
417,
only 417.
only 417. Well,
Learned counsel, Mr. Your name?
you just like, yeah.
You just again, no?
Right.
I is present for the hardly hard learner counsel Mr. User Suikia for the petitioner applicant petitioner applicant Prokunto Tai, who has filed his application under section 430 of the BNW 2023 with prayer for suspension of sentence and with prayer to remain on previous bail as he is convicted under section 417 of IPC in connection with DR case number
Here case number, my lord, the
2325 of 2016
lordship.
to undergo rigorous imprisonment for 1 year and to pay a fine of rupees and sentenced to undergo convicted and it would likhila convicted. It continue koria and sentenced to undergo rigorous imprisonment for 1 year and to pay a fine of rupees 10,000 with default stipulation. Post of this conviction and sentence has been upheld by the learned session judge North Lakhimpur in connection with criminal
Appeal case number 19.
number 19 within bracket 4 bracket close 2024. To stop part Mr. DP Goswami, learned additional PP Assam. I've considered the submissions at the bar. The applicant is hereby allowed to previous bill, no?
Previous year. Remain on previous.
Remain on previous bail as he has already been enlarged on bail by the learned session judge. Okay. By the order dated, is there the order? Have you annexed the order?
My lord, the date of this judgment is 13/5/25.
Meanwhile, the operation of the impugned judgment and order of conviction is stayed until further orders.
Sure.
So I'll dispose it of there.
Sure.
I'll dispose it of. In terms of the above observation, this application stands disposed of. Appellate Lika heard learned counsel Mr. U.J. Soikia for the appellant and learned additional Mr. D.P. Goswami for the respondent who has accepted notice on behalf of the respondent state. Post of issue notice to respondent number 2 to usual process.
Yeah.
Returnable within 4 weeks. Meanwhile, call for the records of criminal appeal number.
Criminal appeal number, my lord, this my lord. 19 within bracket 4/25.
And DR case number
2325/2006.
from the respective courts. Anything else? No.
No.
Admit.
No.
Okay. List accordingly.
But please, Your Lordship. The instant revision petition has been preferred against the order and judgment dated 10 March 2025. Whereby the petitioner has been convicted under section 21B of NDPS Act and sentenced her for a period of 5 years and also fine rupees 30,000 in default SI for 3 months. Along with a IF for suspension of the sentence and along for also seeking bail during the pendency of the petition violation. The petitioner has been convicted without any evidence, on the basis of 2 witnesses. Number
See,
one.
your bail, to consider bail, I'll have to go through the evidence.
Correct. Correct.
So what to do? We'll call for the scan copies
Scan
or
copy. Well, they have also annexed all
Next.
annexed
everything?
all the proceedings.
You have to go through it.
Only 7 witnesses in this case. Not so much.
You want
main
time or we'll call for the scan copies? or-
Scan copy call for it.
We have been remanded for enough 89 days, my lord. also a lady and suffering from
NDPS
serious
method.
illness.
How many days is she behind bars? How many days?
89 days and 20 months since the date of
89
judgment.
days. Okay, what is the contraband?
Contraband was only intermediate quantity 10 point something, 10.77 grams, madam.
Of heroin?
Heroin, madam. And two other co-cases also there, they were acquitted.
Yeah, we can go through the evidence he has annexed.
Yes, Your Honor.
Do we want this conflict?
Only 7 minutes, madam. I have exposed all the prosecution.
Sometimes. Because what is the point of bringing loads and loads of documents?
Okay. 5 years conviction also.
If you want a scan copies, I can call. I think I don't require the scan copies. You want some time?
No.
It's okay.
That's what.
Yes.
My lord. My lord, first of all, madam, here the vital witness in this case, PW1 and PW7. That is the two most important witnesses where the learned court, trial court has convicted the petitioner. PW1 is none other than the police who had lodged the FIR, madam. The sub inspector of police, as well as he is the seizing officer. He is the contraband here. And PW7 is the investigating officer, my lord.
You'll read or I will read. Somebody has to
Yes,
read.
I will read, my lord. Okay. My lord, in the main petition, my lord, you will find the evidences of the prosecution witnesses. Start from page 23, my lord. The PW1, my lord. Stated before the Honorable Court that on 12/2/2022, I was posted at Bipura PSS SI Police. On that day, Inspector Utpal Bada, OC Bipura PS, received one information at 5:30 p.m. that accused Josna Begum selling suspected contraband item heroin at her shop house situated at Bipura Modaiga. Accordingly, OC Bipura PS, myself, UBC, Pranjal, so-and-so went to the place of occurrence. The shop house of the accused Josna Begum in our official vehicle and has interrogated accused Josna Begum and is authorized by the OC Bipura PS. I conduct search operation in the shop house of accused Josna Begum and recovered 13 plastic containers containing suspected to be heroin and 7 numbers of mobile handset and seized the same by preparing cigarettes. During interrogation, accused Josna Begum makes statement that the suspected contraband items heroin kept by her at her house. Thereafter, as well so-and-so. You know, the important point others I have to highlight, my lord. But he has deposed during cross-examination. There's a 3 witnesses, 3 accused persons, along with the present petitioner. Lordship will find in page 26.
No, please read the entire evidence.
FIR, my lord.
No, entire evidence.
Entire,
PW1.
Lordship. Therefore, as led by accused Josna Begum, we proceeded to the rented house where Josna Begum is staying as shown by the accused Josna Begum, recovered 45 numbers of plastic container and 1/2 burnt polythene packet, which she kept under the earth and seized the same by preparing cigarettes. Thereafter, seized 1 weight machines, measured the same suspected to be contraband items. The time of measurement of the contraband items recovered in the shop house of the accused, it weighed 1.66 grams. From 2 persons recovered has been made, weight 1.66 grams, and the contraband item recovered from the rented house of the accused Josna Begum, weight 10.79 grams. In the place of occurrence, we did not conduct body search on the person of accused Josna. And after recovery of the contraband items from her shop, house, and rented, we brought her to the police station, and at police station during body search recovered an amount of rupees 2,770. And thereafter, he deposed. During interrogation, accused Josna Begum disclosed that she buy the seized contraband items by accused Abdul Khalek of Rupohi Nagaon district and selling the same in her rented and in her shop house. Thereafter, the owner of the rented house of the accused Josna Begum is also brought to the police station, and during interrogation, the owner of the rented house, the accused Josna Begum, namely Zubair Ali, stated he restrained accused Josna Begum selling contraband item, but she did not listen to him. Thereafter, I lodged the azhar of the incident before OC PS and handed over the seized contraband items before OC Bipura PS. Exhibit P1 PW1 by PW1 is the azhar lodged by me, wherein so-and-so is my signature. And again, the exhibit P2 is the signature so-and-so, Your Honor. And again, Your Honor, in page 26, Your Honor, in cross party, and it's very important, my lord. The Azahar was lost after apprehending accused Dusna Begum and seizure of contraband items. I have PPL all the seizure lists. I hand over the seized articles with seizure list to the OC PS, and thereafter lost Azahar. OC, after registering PS, endorsed the case for investigation to another IO. We proceeded to the place of occurrence at 6 p.m. on 12/2/2022. OC BPAPS accompanied us to the place of occurrence and returned to the police station at 8:35 p.m. And after searching and recovering contraband items at shop house and then from the rented house of Ekujusna Begum, I entered all the activities in MCD by myself. The information was received by OC BPAPS. This is very important, Your Honor. My lord, and OC BPA, my lord.
Will not get into the merits.
Well,
I'm
ma'am.
not hearing an appeal.
Mile. I entered all the activities and see myself. As information was received by OC BPAPS, and OC BPAPS made GD entry in the general diary kept at BPA police station by GD entry number 317 dated 12/2/2022. The GD entry number 317 dated 12/2/2022, we speak the date of receiving the information. The seized contraband items does not require scene and seal of the IO. I cannot say what OC did upon handing over seized contraband items to OC BPAPS. I have recorded statement of Ekujusna Begum and her landlord and seizure witnesses. I have drawn up this case map of the place of occurrence. In Exhibit P4 by PW1 seizure list, I have not mentioned the place of seizure, though name of the persons from whom the seizure has been made mention. Exhibit P4 P by PW1 was prepared at the shop house of the accused. The rented house of the accused Dusna Begum in the separate compound owner Zubaid Ali. I did not mention how many rooms are there in the rented house of the accused Dusna Begum. I made notices of those persons who gathered at the place of occurrence at the time of seizure of the contraband items. In Exhibit B3, I have not mentioned the search made at the BPA police station. It is not a fact that no any incubating contraband item is recovered from the position of the accused Dusna Begum. Again, my lord,
These are for Zubaid Ali.
My lord,
This examination is for Zubaid Ali.
Zubaid
This is not
Ali
required.
subsequently, but there is 3 accused persons, Bulbul Rahman, Zubaid Ali, and Dusna Begum. Present petitioner is before law office, Dusna Begum, my lord.
So I am going only for
Dusna Begum, my lord.
evidence only for
Dusna Begum, my lord.
PW2 is not required.
My lord. PW, then all there are the seizure witnesses, though they have not supported
They have not supported it.
the prosecution witness at all regarding the seizure.
See, I am not going to the merits.
My lord. PW7, my lord. The important PW7 the IO of this case, my lord. But you will find the PW7 at page. This from page 50, my lord.
Yes.
This is the last witness, my lord.
I'm
Or
just
not-
going to evidence of other witnesses.
My lord.
PW2, 3, 4.
My lord,
They have not
PW2.
supported the case.
They have not supported the case, my lord. PW2 deposed before the,
I have read it already.
my lord.
Yes, just a moment.
Recovery was made from her house and otherwise,
Only PW1 and PW7.
yes,
Seven.
PW1 and PW7. Other witnesses are
Otherwise, there's admission also in the
No.
evidence.
not.
PW5 is sort of implicated. Not directly, but little bit of support from his evidence.
In cross, my lord, the PW5 had not denied,
Cross, I'm not going into the merit.
my lord.
Yes, what do you say?
Okay, but this
89 days can be granted.
can be and
Third learner
I may be
conference.
disposed of and main appeal.
Yes. we'll fix date because now they will disappear
Lordship.
after bail.
My lord, my lord, my lord. No, my lord, I will leave you, my lord.
Third learned counsel, Mr.
Yes, good.
S. Gogoi
Go with it.
for the applicant Mohammad Dusma Begum, who has filed this application under section alage 413
My lord, yes. Good.
under section
430.
430 of the BNWS 2023 with prayer for suspension of the impugned judgment and order dated 10/3/2025 passed by the learned session judge, special judge Lakhimpur, not Lakhimpur in connection with special NDPS case number 5 of 2022, convicting the appellant under section 21 within bracket small b of the NDPS Act and sentencing her to undergo rigorous imprisonment for 5 years and to pay a fine of rupees 30,000 with default stipulation. Third, Mr. DP Gutfami, learned additional PP Assam. The learned counsel for the applicant has submitted that all the documents relating to the evidence of all the witnesses has been annexed to substantiate the cause of this application, full stop. It is further submitted that the evidence of the witnesses does not implicate the applicant at all, full stop. The evidence of the complainant and the investigating officer has been relied upon by the learned trial court to convict the appellant. Any other ground about this lady?
My lord, she is suffering from, I have enclosed a medical document, she is suffering from severe thyroid. I have enclosed, she will find in I, my lord, page 22, annexure 1, my lord. No, my lord, the medical documents will file, she will find the medical documents. Annexure 5, page 26, my lord. Since 2023, my lord, she is suffering from thyroid.
Annexure 5 of the appeal.
Normal, I, my lord.
I-
I.
All right. It is further submitted that the appellant is suffering from increased prevalence of subclinical thyroid disease. It is further submitted that if enlarged on bail, the applicant will cooperate with the appeal. Full stop. It is further submitted that there is every possibility that the applicant may be acquitted owing to the discrepancies in the evidence which has been ignored by the learned trial court. I have considered the submissions at the bar with circumspection. I have considered the submission that the applicant is suffering from severe thyroid disease and has also pledged to cooperate with the appeal, full stop. The merits of this case is not discussed as appeal is pending for disposal. Considering all aspects, it appears that the appellant may be, she's forwarded to custody, no?
Yes, ma'am.
Appellant may be enlarged on bail of rupees 50,000 to the satisfaction of the learned trial court. The trial court may impose conditions which the court deems fit and proper. Meanwhile, the operation of the order of conviction and sentence dated 10/3/2025 in connection with special NDPS case number 5 of 2022 is stayed until further orders. So I'll dispose it of.
I may be disputed.
In terms of the above observation, this application stands disposed of. This is revision petition.
Repeat petition.
No, I'll recall this order. It has to be an appeal.
Oh. 5 years only.
5 years from now.
Should be an appeal.
Has to be an appeal.
My lord.
I'm recording this order. You rectify it.
Regarding,
Type You rectify it through anything application. I'll not rectify it.
my lord.
I have the power, but I won't. It's
I will
a
rectify it.
serious matter.
I will let you. I'm ready, please.
Yeah. Nalagi. I'll give an adjournment on your prayer.
Order.
Learned
Gotcha.
Counsel Mr. S. Gugoi has prayed for adjournment. Is the matter after 1 week?
1 4.
May it please your lordship. My lord, these two cases, one has been filed in the capacity of an individual and other in the capacity of, my lord, proprietorship.
Hmm.
Now, my lord, if your lordship would kindly come to this criminal revision 190 of 25, the judgment of the trial court at page number 34. My lord, the petitioner, my lord, has discharged his onus by rebutting evidence. Kindly come to page 34. PW1 in his cross-examination has stated that Messrs. BD Trading is the sole proprietorship firm and is run by himself. He filed the case in the name of BD Trading. PW1 denied the suggestion of BD Trading is not eligible to file the case against the accused person. PW1 further stated as he has good relation with the accused, they had business transaction between them. He filed the case against the accused as he is entitled to get a sum of rupees 35 lakhs from the accused, and he has stated about it in his evidence in chief on affidavit. He gave the sum of rupees 35 lakhs to the accused period during the period from January 22 to July 22. He filed the income tax returns. He has not submitted any documents relating to his income tax payment in connection with the case. PW1 further denied suggestion that he did not pay sum of rupees 35 lakhs to the accused during the period January 22 to July, as he did not have such huge sum of money. He had not mentioned in either of the complaint or evidence in affidavits the specific date and time of payment of 35 lakhs to the accused person. PW1 further denied the suggestion that the bank statement is forged and was prepared by him and was not issued by the bank concerned. PW1 further denied the suggestion that as there was no legally enforceable debt pending from the accused to him, the accused was not liable to pay check bearing number so and so for rupees 15 lakhs. He has filed another, now this is very important, my lord. He has filed another case before the Dumduma PS against the accused in connection with dishonor of the check, and it is numbered as Dumduma PS case number so and so. PW1 admitted that he has stated in the FIR that dated 14/9/22 before the Dumduma that he lent the sum of rupees 25 lakhs. Now 35 lakh has become now 25 lakhs. That's a case for remand. Then my lord will kindly. So my lord, there are three improprieties which the court could not notice. Now lordship, the Supreme Court has said, when it comes to very huge amount, your accounts, your statements must show that you are financially capable. Now he did not submit any, financial statements. Secondly, my lord, then there is no evidence on record as to on what day this sum was given. And thirdly, he admits that while filing a FIR before the Dumduma PS, the amount was 25. Now, my lord, this two amount has been appropriated in the two cases. In this case, it is 17 lakhs. In the other case, it is 12 lakhs. Now, kindly see the DW1's person, my lord. DW1 in his examination in chief has stated that he knows both the complainant and the accused person of the instant case as they were known to each other. Well, DW1 is not the Milord petitioner before Lordships, is a somebody else, is a business accomplice. So and so. The complainant with an intention had deliberately misled this court by filing the instant case with false statement that the accused along with his father had approached the complainant and took a sum of rupees 35 lakhs only from the complainant in the name of supplying green leaves as the accused deal in collecting green leaf from the locality in this regard. The complainant sometimes issued challan and sometimes not against supplying green tea leaves to the accused, as is also one of the suppliers of green leaves to the accused. DW1 further deposed that he knows that the complainant on various dates had paid an amount of rupees 22,75,000 only to the accused person as loan out of so and so in the name of purchasing green leaves, tea leaves from the accused and not 35 lakhs as it is mentioned by the complainant in the present complaint case. However, the accused had returned an amount of rupees 10,89,590 to the complainant, and from the bank statement of the complainant, as it is clearly mentioned that amount of rupees 7 lakh has been returned to the complainant by accused number 1. DW1 further stated that the remaining existing liability of the accused towards the complainant has supplied the green leaf which was being collected from the locality and for which sometimes the complainant issued challan in his regard, and hence the accused had repaid the entire amount of 22 lakhs to the complainant. Lordship knows when it comes to my burden, my lord, this is my lord, the burden of proof is preponderance of probability. So I have discharged my, duty, my lord. I have shown that there is nothing remains. Yes, there was some business transaction between the two. But where is the evidence that in fact 35 lakh was given to me? He himself says in the Dumduma PS when he files the FIR it was 25 lakh. Actually it was 22 lakhs and odd which has been returned, my lord.
So what is the compensation awarded?
Now, my lord, in this case it is 17 lakhs in lieu 8 months of RI, SI, and in the other case 12 lakhs. My lord, lordship knows there is a presumption, but presumption is rebuttable, and I have rebutted my presumption. When it comes to my standard of proof, it is preponderance of probability. Now, by DW1's evidence, everything is clear.
But this any imprisonment, sentence of imprisonment?
No, there is no allegation of embezzlement. That is not there.
No sentence of imprisonment?
Yes. Page number 48, my lord. Accordingly, the convict is sentenced to pay fine of rupees 17 lakhs 50,000 in default in payment of convict. A1 shall undergo imprisonment for a period of 8 months. And in the other case, my lord, it is 12 lakhs and odd, and in lieu thereof, it is 8 months. Well, prima facie, my lord, it's a case for remand, my lord. There is no finding as to how this figure of 35 lakh was arrived at. Where is the evidence? On what date the checks were issued, my lord? When it comes to the burden of the complainant, my lord, it is beyond any reasonable doubt. But when it comes to my burden, it is preponderance of probability. And DW1 has discharged his burden, my lord. Now, what remains in this case? And lordship knows there are 2 Supreme Court judgments on this point. If I may be permitted to only one judgment, my lord, AIR 2023 Supreme Court 471. এখন দিয়ক না। If your lordship should kindly come to paragraph 10, my lord. As far as the facts are concerned, lordship can notice at para 10. The learned counsel submitted that there arose no occasion for the appellant Rajaram to issue a blank check in the year 92 for a check to be subscribed much later in the year 95. It is further submitted that even if certain amounts are not accounted for in the income tax return, this is a matter concerning only the defaulter and revenue authority. Thus, a borrower cannot be allowed to take advantage of the same solely on the ground that such amount is not reflected in the income tax return. The argument was, my lord, it's a matter between the defaulter and the revenue authority. Therefore, one cannot take advantage. Supreme Court says no. When you are showing that you have lent out money, then you must have the financial capacity. And financial capacity will be reflected in your income tax return. Here in this case, they have not produced any income tax return, my lord. Now, para 11, we shall first consider the criminal appeal. Now, please come to my lord, paragraph 25.2. The presumption under section 139 is rebuttable presumption, and onus is on the accused to raise the probable defense. The standard of proof for rebutting the presumption is that of preponderance of probability. So, by application of the standard of proof for preponderance of probability, I have discharged my burden. Now, kindly come to para 13. It can thus be seen that this court has held that once the execution of a check is admitted, Section 139 of the NI Act mandates a presumption that the check was for discharge of any debt or other liability. It has, however, been held that presumption under 139 is a rebuttable presumption and onus is on the accused to raise the probable defense. The standard of proof for rebutting the presumption is that of preponderance of probability. It has further been held that to rebut the presumption, it is not open for the accused to rely on evidence laid by him, or accused can also rely on material submitted by the complainant in order to raise the probable defense. It's not that, my lord, only on the materials which is brought forward by the accused that will only be decisive. No. To discharge this presumption, my lord, he can also rely upon materials which is brought forward by the complainant. Now, here in this case, my lord, we have clearly shown all that was given was 22 lakhs and odd, which out of which, my lord, 10 lakh was repaid in one installment and rest were adjusted against supply of green leaves. So what remains in this case, my lord? So where from this figure of 35 lakhs comes? Where are their income tax return? My lord, on the point of income tax return, please have the judgment, my lord. Air Online 2024 Supreme Court 550, para 27. Para 27, my lord. Applying the aforesaid legal position to the present factual matrix, it is apparent that there existed a contradiction in the complaint moved by the appellant as against his cross-examination relatable to the time of the presentation of check by the respondent as per the statement of the appellant. This is to the effect that while appellant claimed that check to have been issued at the time of advancing the loan as a security, however, a statement during cross-examination, it was revealed that the same was presented when an alleged demand for repayment of alleged loan amount was raised before the respondent after a period of 6 months of advance. Now, this is important. Furthermore, there was no financial capacity or acknowledgement in his income tax return by the appellant to the effect of having advanced loan to the respondent. So this is a relevant consideration, my lord. In that view of the position, my lord, I think, my lord, after appearance of the other side, Lordship would like to remand the matter, my lord. The amount based on which the adjudication has been done is absolutely, my lord, absurd. There is nothing on material.
This was for the stage of motion.
Yes, my lord, first time it has.
There is no prayer for waiving 20% of the fine amount.
My lord.
Are you praying that? Are you asking for waiving 20% of the fine amount? I'll stay. I
Yes.
can't stay.
My lord.
I'll grant stay, but
Stay only, yes, yes.
you'll have to pay 20% of the fine amount to the which court do you want to pay? Here or
There, my lord.
there? Okay. So both the cases then 20% of the fine
That, my lord, statutory thing. Lordship can 10% will pay for the president.
20% because there's no prayer extra petition for waiving, so 20%. Others
Or
this
lordships
would have
can,
been considered.
regarding that, we can file an IA, my lord, that can come on a later date. Today, lordship will consider this.
But he was willing, no? He was willing, he was agreeing. Very happily, he was agreeing. Our learned senior counsel, Mr. K. N. Chaudhary. Assistant learned counsel, Mr. T. Devrino. For the applicant, for the petitioner, Arman Chakraborty alias Sunny Chakraborty, who has filed his application under section 442 read with section 438 BNWS 2023, challenging the judgment and order dated 3/3/2025 passed in connection with criminal appeal number 39 within bracket 4/2024 passed by the learned additional session judge Tinsukia, dismissing the appeal and upholding the judgment and order dated 8/11/2024 passed by the learned judicial magistrate first class Tinsukia in connection with NI case number 257 of 2022, convicting the appellant under section 138 of the NI Act and sentencing him to pay a compensation of rupees 17,50,000 with default stipulation.
It's a one.
Mr. D.P. Goswami, learned additional PP, Assam, for the respondent number 1. Which of the respondent number 1 has accepted notice on behalf of the learned additional PP has accepted notice on behalf of the respondent number 1, and thus no formal notice is required to be issued. Full stop. It is submitted on behalf of the petitioner that this is a fit case to be remanded back. So there is not an iota of evidence that 35 lakhs has been paid by the petitioner to the respondent number 2. Full stop. It has been the liability the liability of the petitioner is to prove his case on the preponderance, to establish his case on the touchstone of preponderance of probability, which he has
amendment they do.
it is submitted that the petitioner has returned the amount of rupees 10,89,590, and the remaining amount has been adjusted with the green tea
Again,
leaf,
supply of green leaf.
with the supply of green tea leaf by the petitioner to the respondent. Full stop. It is further submitted that the petitioner, without submitting his income tax return, or respondent number 2, without submitting his income tax return, has failed to prove that he has sufficient income to lend a huge amount of rupees 35 lakhs to the petitioner. Stop. It appears that the further proceedings of the that the operation of the impugned judgment and orders, the operation of the judgment and orders impugned by the petitioner can be stayed. Full stop. Thereby, the operation of the impugned judgment and order dated 3/3/2025 in criminal appeal number 39/4 2024, and the interim judgment and order dated 8/11/2024 in criminal numbers. No, no, criminal appeal number none. In NI case number 257 of 2022, is stayed until further orders, subject to the condition that the petitioner deposits 20% of the fine amount before the trial court,
Yes.
before the trial court within 1 month, 2 months,
Actually, 60 days is permitted under
2
the
months,
provision, 2 months.
within 2 months from today. A call for the trial court records of the, call for the aforementioned trial court records from the respective courts. Issue notice to the respondent number 2, returnable within 4 weeks. As per usual process, returnable within 4 weeks. List accordingly.
Well, in the
Other-
next case, the amount is 12 lakhs. Otherwise, same evidence, everything is same.
Everything is safe, 12 lakhs, or he can name. And the parties are also same.
Same. Only in the capacity of the, proprietorship, here in the capacity of an individual.
So this will be helpful on final submission. I'm
Yes,
keeping
yes,
it here.
yes, yes, yes.
Itu case course. Proprietorship form is also same.
Yes.
Everything is same, no? 12 lakhs, 50,000, 10 lakhs or jagah. Only this much difference.
12 lakhs there, Mila. Here it was 17 lakhs and not, here it was 12 lakhs.
17 lakhs or jagah 12 lakhs likhi diba. 7 lakhs 50,000 kipa ki bhi asal hai.
Well, item number 1 in the capacity of individual and item number 2 in the capacity of proprietorship. Second matter.
I'll correct it.
Yes, yes.
I'll correct it. He'll get confused.
You'll get deep level.
Eto dot di thodi ba mo correct kori dim. Matru naam to dot di thodi ba. Item 5.
May I please, your lordship. Lordship, here, lordship, I have filed this petition for quashing the entire proceedings, lordship, arising out of an FIR, lordship. That is at page number 17. Respondent number 2 is appearing, lordship. This is on the basis of compromise, lordship.
This is motion stage, no?
Motion stage, lordship.
So, not joint
Page.
petition.
My lord,
Not joint petition.
no, not joint petition. He is appearing, lordship. Page number 17, lordship. Small FIR, lordship. May I read it, lordship? Page number 17, my lord. With due respect, humble submission is that on 17/2/2023 at so-and-so, while the accused person was coming from his residence by riding a bike bearing number so-and-so with a high speed, then on his arrival at so-and-so area, he collided and caused severe injury on my mother, so-and-so. I, with the help of other person, took my mother to Nagar PSC for treatment, but the doctor on duty declared my mother as dead. Thereafter, lordship, charge sheet was submitted, lordship, that is at page number 30. Charge sheet was submitted, page number 30. Second paragraph, lordship. On the basis of the FIR, a case has been registered so-and-so under section 279/304 IPC and investigated. During the course of investigation, thereafter, lordship, on the basis of evidences under the same section 279/304A IPC, charge sheet was submitted. Now, lordship, may kindly come to page number 33.
FIR was a page number?
FIR, lordship, was
Page number 17.
page number 19, lordship. Yeah. Oh. Page number 19 was the FIR, lordship. 17, lordship, sorry.
Okay, page number?
Page
Now
number-
page number 33.
Page number 33. Now, lordship, may kindly come to page number 34.
All right.
Last paragraph, lordship. It is true that at the time of the said accident, I was at my workplace and I have not witnessed the incident. Moreover, the SR was so-and-so, so-and-so. After the said accident, recently the rider personally met with us and helped and support me and my brothers and sisters financially and mentally. Since the accused is a good neighbor of mine and my other family members since our birth, and he has not committed any such offense earlier with my family. Moreover, he is very regretful for the said incident. So, with this affidavit, I so-and-so, complainant of this case, declared that I do not have any grievances against so-and-so in connection with the above case, and I do not want to continue the case against him.
Now, Lordship, whether Lordship is this Lordship which are registered under section or charge sheet which charge sheet has submitted under section 279 and 304A can be quashed or not, Lordship. We like to rely on certain judgments, Lordship.
Yes,
My Lord, may kindly take up the first judgment, and Lordship may kindly come to paragraph number 4, Lordship, page number 2.
yes.
The facts of the case is that respondent number 2 as informant lost an Izaha dated so and so, alleging inter alia that on so and
Page
so.
number 2.
Page number 2, paragraph 4, Lordship.
What is the, okay, okay. All right.
Compilation, Lordship.
Yes, yes.
The facts of the case is that the respondent number 2 as informant lost an Izaha dated so and so, alleging inter alia that on 8/3/2020 at around so and so, while the informant respondent number 2 along with her husband were proceeding from their house so and so to so and so from for household marketing, and when they reached at so and so on so and so, one vehicle bearing registration number so and so driven by the petitioner in a rash and negligent manner knocked down the husband of the respondent number 2. As the result of the said accident, husband of the respondent number 2 was died on the way to hospital.
Yes.
Now, Lordship may kindly come to page number 3, paragraph
number
number
three.
8, Lordship.
Hmm.
Only one paragraph I will read, Lordship.
Okay.
Subsequently, the petitioner number 1 and respondent number 2 have amicably settled their dispute by clearing their misunderstanding, and in this regard, respondent number 2 had executed an affidavit before the notary public so and so, which is annexed as Annexure 3 to this petition, wherein the respondent number 2 declared to the effect that she will have no objection if the Honorable Court quash the impugned FIR in so and so PS case number and incidental proceeding of PRC case number so and so, pending before the learned so and so. In the aforesaid backdrop, this court is now to decide whether this is a fit case where this court can exercise its inherent power under section 482 of CRPC to quash the impugned FIR in so and the incidental proceeding PRC case number so and so. Now, Lordship, thereafter, Lordship, the judgment of Gyan Singh and Lakshmi Narayan was referred to, page number 4. And finding, Lordship, page number 5. From the material, page number 5, Lordship, paragraph 13. From the material available on record, including the affidavit filed by the respondent number 2, this court is of the view matter relates to dispute which are private in nature and do not have any serious impact on society. On the ground that there is settlement compromise between the petitioner and respondent number 2, this is a fit case where the power under section 482 can be exercised as held in so and so. Accordingly, the petition is allowed and set. The subsequent judgment, Lordship, I have cited in as much as Lordship 7 judgments. Of our High Court, Lordship, there are 4, and one of Delhi High Court and 2 of Supreme Court, Lordship. Same issue, same decision.
All right. You have no objection.
No decision. We have ambiguously settled.
Third learned counsel, Mr.
M. Ahmed.
M. Ahmed. Item number 5, no?
Item number 5, ma'am.
For the petitioner, Devasis Sinha, who has filed this application under section 528 of the BNWS 2023 with way for quashing the entire proceeding of GR case number 488 of 2023 arising out of RK Nagar Police Station, case number 42 of 2023, registered under sections 279 stroke 304A of the IPC. Art Mr. D.P. Goswami, learned additional PP Assam for the respondent state, and learned counsel Mr.
A. Rahman.
A.R. Rahman.
A. Rahman.
A. Rahman. A. Rahman for the respondent number 2, Ranjit Bean. It is I have considered the submissions at the bar with circumspection. It is submitted at the bar that the informant's mother met with an accident and died as a result of the accident. The petitioner was riding the motorcycle bearing registration number AS 241B P172, which was involved in the accident, and the respondent number 2, informant's mother Raskumari Bin, died as a result, died as she was knocked down by the motorcycle. By the aforementioned motorcycle. The learned counsel for the petitioner has drawn the attention of this court to Annexure 5, which reveals that the petitioner was not aware, Annexure 5 of the petition, which reveals that the petitioner was not aware that his mother met with an accident as he was not present at the place of occurrence. To the affidavit, it is also submitted that the respondent number 2 has no objection if the entire proceeding is quashed. The petitioner has relied on a decision of the coordinate bench of this court in criminal in Elias Hussain, ELIYS Hussain versus the state of Assam, and another wherein by order dated 21/8/2023 in criminal petition number 384 of 2023, it was observed that para 13. It has been held by the Honorable Supreme Court in Lakshmi Narayan's case.
Yes, Lordship. Lordship, paragraph 9 to 13 may be quoted, Lordship. The purpose could be served.
Entire paragraph is not required.
Otherwise,
We can quote the Lakshmi Narayan's case also.
yes, Lordship. That is at paragraph number 12.
It has been held, that famous case, it has been held in, it has been held by the Honorable Supreme Court in state of Madhya Pradesh versus Lakshmi Narayan and others, quoted in 2019 5 SCC 688.
Paragraph 13, Lordship. That is at paragraph number 12 here.
To para 12 আছে para 12 পৰা গুটেটো লিখিব নালাগে 13 বুলি লিখিতে হৈ যাব এই ইটালিক্স অফ পাৰ্ট সব ব্লু ট্যাগ কৰি থৈছে the instant case to also reverting back to this case, it is held that the instant case is a matter which is private in nature and do not have a serious impact on the society at large. Full stop. Both the parties have amicably settled the dispute, and it appears that possibility of conviction appears to be remote and bleak, as the informant is not willing to proceed against the petitioner. Full stop. Thereby, thus further proceeding will indeed be an abuse of the process of the court. The petitioner, in the wake of the foregoing discussions, I deem it appropriate to quash the proceedings arising out of so and so case, PS case number, incidental to GR case number. Okay,
First.
in terms of the status,
And
Yep. I'll correct it. To me, case number more correct. In terms of the above observation, this application stands exposed.
high level.
You can take it back also if you require.
That is it.
Hmm.
But also this is an IFR application under section 5, read with section 3A of CPC for condemnation delay of 8 days in filing the regular first appeal against the impugned judgment and decree dated 12/8/24 as by learned civil judge senior divisions Barpeta. That's it. As per
Issue
the-
notice, issue notice.
That's-
Issue notice, 8 days.
That's it, notice by visa, because the delay is not intentional and willful one.
It's okay, we'll condone it. 8 days, but you'll have to issue notice.
That's it. Notice by visa.
Learned Counsel, Mr.
S.A. Bakhtiar.
S.A.
S.A. Bakhtiar in the cost.
Bakhtiar is present for the appellate. Stroke applicant. Full stop. Appellant to take steps, applicant to take steps to issue notice to the respondent. One respondent.
Responding.
Respondent, we'll see, let's see, we can condone it afterwards.
That's
If the notice is served, they don't appear, also we can condone it.
There is one performer and other four principal respondent, opposite parties,
Respondents,
respondents.
returnable within how many days?
1 week,
1 week. You want a date fixed?
no date.
It's an urgent matter, you don't want a date.
No date.
Within 1 week, list accordingly. As per usual process, returnable within 1 week, list accordingly. All right,
By registered post and usual process.
by registered post as well as by usual process,
That's it.
both.
Much obliged.
Maybe okay. My lord, this is a quashing petition filed, my lord, on the ground of, my lord, it is a false case as well as, my lord, in the meantime, my lord, matter is compromised, my lord, and petition, informant respondent also approached before the IO, my lord, with a request, my lord, not to proceed with the case, my lord, but case was subsequently, my lord, charge sheeted, my lord. It is a long pending case also, my lord. It is a Algapur PS case number, my lord, 2020, my lord. FIR, my lord, at page on relevant portion, page 10, my lord, annexure 1, my lord. It was complaint case turned, my lord, PS case, my lord. And lordship, I beg to, my lord, refer just date of, my lord, incident and date of information received, page 13, lordship. Kindly have a look. Alleged date of incident occurred, my lord, page 13, under clause 3B, my lord, it is 16/12, my lord. And information received on, my lord, 6/1/2020, my lord. After more than, my lord, 15 days. Thus, my lord, allegation and relevant portion of the FIR is starting from,
FIR was lodged on 6/1.
yes, my lord.
FIR actually, it is not an FIR, it is a complaint.
Complaint case one. Relevant portion, my lord, page 11, my lord. She was a major girl, my lord. According to her allegation, she was about to come from, my lord, Silchar, one place, Silchar, my lord, Bagabajar, to her house.
Statement is not very clear in the FIR, but we have filed the additional affidavit.
What vehicle? This is criminal petition relating to what?
This is relating to, my lord, an agreement which was there between the parties.
Okay.
That one. So the
Uh,
only issue was whether
Hire
the
purchase agreement.
it's a hire purchase agreement. Yes, it was for a construction work in Nagaon.
And I have filed the document which shows that the vehicle was returned by the company on 4/3/2022, whereas the FIR was lodged on 1/9/2023.
The vehicle was returned on
4/3/2022. And that it is written in the document that it was returned in good condition. Actually, my lord, what has happened in this case is very simple. The only dispute was that during the COVID period, there was a lot of number of days where the vehicle was not used because obviously there was a ban on the construction activity. So the dispute between the parties arose as to whether I am liable to pay the amount for that COVID period or not. That is also there in page 42, which I have filed the affidavit, that this part will be negotiated between the parties. Now, in this negotiation, there a problem arose. Dispute arose. And in 2023, which your lordship will find that 1.5 years after this vehicle returned, then the informant went and filed an FIR and said that
when was the FIR filed?
1/9/2023.
2023.
The entire dispute is civil in nature. Lordship will stay the proceeding before the lower court in the meantime, because it is now the next date is 8th of July. So Lordship will kindly stay the proceeding and fix an early date. We can, matter can be heard in this.
Hard learned counsel, Mr. E. Ganguly for the petitioner J.S. Parijat, alias Parijat Swetia, who has filed his application under section 528 of the BNWS 2023 with prayer for setting aside and quashing the entire proceeding of PRC case number 151 of 2024 under section 420 of the IPC arising out of Bongaigaon PS case number 363 of 2023 under section 420-507 of the IPC. Heard Mr. D.P. Goswami, learned additional PP Assam. What is your submission? Full stop, D20.
As per they have handing over the vehicle on 4/3/2022. In this case, Sarsit submitted on 30/11/23. During investigation period, we have returned the vehicle in the time, but in the but
4020 to 301123 that charge has been submitted. Yes.
30/11/23 Sarsit submitted. And they have returned the vehicle as per their it is repeated. 4/3/22.
Will stay. You have any objection relating to the prayer for stay?
Yes, Parthiv, I have paid photograph. Additionally, maybe record to be called for and notice to issue to the party.
He learned additional 50 tests. Raise objection stating that although through the additional affidavit, the petitioner has submitted that the vehicle has been returned. The vehicle in dispute has been returned on 4/3/2022, yet charge was laid against the petitioner on 30/11/2023. Is submitted on behalf of the petitioner that an agreement was executed between the petitioner and the respondent number 2. In the year 2022, and the allegation against the petitioner is that the petitioner had hired the vehicle from respondent number 2 for monthly payment of a rent of rupees 1,20,000 for 1 year, but he failed to pay the higher charges in time, and he also did not return the vehicle, comma, which is a JCB SK Vetter JCB SK Vetter bearing registration number AS 19A C 2671 full stop. It is further alleged that the vehicle was kept for an extended period of 4 months, and the informant was paid only rupees 7,74,000, while the entire amount was misappropriated by the petitioner, who has refused to return the balance amount and has blocked the calls of the respondent number 2. Full stop. It is further submitted that this is a civil case in the garb of a criminal case, and the Honorable Supreme Court has and there are several guidelines of the Honorable Supreme Court not to proceed in criminal cases which are filed instead of civil, which are brought up instead of taking recourse to civil cases. The petitioner has drawn the attention of this court to the work order marked as annexure
Annexure 3.
to the work order marked as annexure 3 of the petition. What was the purpose of the work order? I could not recall.
Purpose of the work order is for certain, certain construction works at Nagaon. In fact, the work orders itself mentions the works for installation and commissioning of DL pipes for distribution network in Nagaon town, Assam.
On the basis of this work order, this vehicle
Yes.
was hired.
Yes.
And on the basis of this work order, annexure 3 ligila, no? This vehicle, the aforementioned vehicle was hired way back on
The 30th of October.
30/10/2020, whereas the FIR was lodged in the year 2023. Clause 15 of the work order reflects that on any dispute, the jurisdiction of courts in Guwahati, or the dispute will fall under the jurisdiction of the courts in Guwahati. Is it correct?
That is clause 15. No? In case of any dispute, basically it refers to the civil court, civil disputes. Criminal.
Which implies that the criminal petition was erroneously criminal case was erroneously proceeded upon by the court at Bongaigaon, full stop. By the court at Bongaigaon. The petitioner has further drawn the attention of this court relating to the bail, anticipatory bail order granted to the petitioner, as no prima facie case was found against the petitioner. The anything else you want to refute? No. It appears that the petitioner has a prima facie case for interim stay. It appears that further proceedings of the PRC case number 151 of 2024 may be stayed. Call for the scan copies of the trial court records along with the. This was a proper FIR, no, not a complaint case.
No, isn't it fair?
Along with the scan copies of the CD. Issue notice to the respondent number 2 to returnable within, as per usual process, returnable within 2, 3, 4. How many weeks?
4 weeks no, because
4
vacation
weeks.
is there.
Hmm?
The intervening vacation is there.
4 weeks. Meanwhile, further proceeding of the aforementioned case shall be stayed till the next date of listing.
Pending before the court of the learned additional CM. That part I think Lordship said not say.
So we will add it.
Lordship.
She will add it.
Deeply.
Next, we will Lordship, 528 application for quashing and setting aside of order dated 21/3/23, Lordship. Annex 3, page number 36. There is a deed of settlement between the parties, Lordship. Page number 33 is the operative portion. In
Yes.
in the para number 1, condition number 1, it was said that a second party is agreed upon the counseling before the honorable councillor to the family court to the proposal of the first party of 40% deduction of his take-home salary, Lordship.
Yes, yes.
But in this order, Lordship, there is no mention whether it is 40% is deducted from the take-home salary or gross salary.
Okay. Take home salary.
Lordship. But in this order, it is not mentioned in.
You for the husband.
Lordship.
So they're deducting the gross salary.
Gross salary, Lordship. And it's policy page number 40. His gross salary is 59,341 baht. And amount of rupees 23,700.
Page number?
Page number 40, Lordship. His gross pay salary is 59,341, Lordship. But an amount of rupees 20.
Page numbers, just once more. Page number?
40, Lordship.
40.
40.
Okay. gross salary is 50,000.
59,341.
So deducting for 50% will be, they're deducting 30,000, 25,000 maybe.
25,000 years loss. 23,000, 40% loss, 23,736 from the gross salary.
We'll hear the other side.
Lordship,
She's a woman, we'll hear the other side.
Lordship.
Will issue notice? Because his son and wife, 40%. He's not new married again, no? Is he?
No.
He has to take care of his parents.
Yes, Lordship, yes.
We'll hear the other side.
Lordship,
Third, Miss
the doctor.
D. Dr. Learned Counsel for the petitioner, who is aggrieved by the order dated
21/8/23.
21/8/23 passed by the Learned Principal Judge Family Court number 2 Kamrup M Guwahati in connection with FC within bracket criminal number 201 of 2023. Petitioner to take steps to issue notice to the respondent through register post or usual process.
Registered post.
Through register post with AD, returnable within 2 weeks.
Lordship.
2 weeks. Meanwhile, call for the scanned copies of the trial court record. Case is still pending.
Yes, Lordship.
Trial court record. List the matter on. List the matter after 2 weeks.
Right. Please, Lordship.
May I please, Your Lordship? Your Lordship, for quashing of NBW issued on 24/3/25 in PRC case number 71/2025, Your Lordship. Your Lordship, this is charge sheeted case, Your Lordship. The imping order, Your Lordship, page number 41 is the order where NBW was issued against me, Your Lordship. The charge sheet was, in the charge sheet, I was shown as absconder, Your Lordship, though I was not. Your Lordship. I am ready to appear and face the trial, Your Lordship, at this point of time, Your Lordship.
Murder case, what do you have to say? Absconder, quashing of charge sheet.
Not quashing, Your Lordship. NBWA issue. NBWA issued and here.
Quashing of the NBW.
NBW. I am ready to face the trial, Your Lordship. Page number 41 is the imping order.
Let him appear and trial court will decide on merit.
Yes, you will appear.
Oh, Lordship.
I'll keep it in abeyance, NBWA.
Lordship.
Third Learned Counsel, Mr.
R. Chetri.
R. Chetri for the applicant Monjit Suikia, who has filed this application under section 528 of the BNWS 2023, read with section 438, 442 of the BNWS, challenging the order dated 24/3/2025 passed by the learned SDJM M. Jorhat Assam in PRC case number 71 of 2025 under section 294/326/302 by 34 IPC, issuing NBWA against the petitioner. Heard Mr. Your name? Anybody's name? Jointa Sutia sitting since morning. I'll give his name.
Yeah.
J. Sutia, learned additional PP for the respondent state. I have considered the submissions at the bar. The petitioner is, it is submitted on behalf of the petitioner that the petitioner is willing to cooperate with the trial. Full stop. He he has been shown as absconder in the charge sheet, but the petitioner was not avoiding investigation. And now the petitioner is willing to cooperate with the trial. The petitioner is apprehending arrest as on his appearance before the learned SDGM S, no? SDGM S or M?
SGM M Titabor,
SDGM M,
Titabor District Jora,
Titabor.
Titabor.
Titabor. He may be forwarded to custody. I have taken a pragmatic view. The petitioner is willing to cooperate with the trial, he is directed to appear before the learned
Next fix on 16/6/2020.
learned magistrate. Till then, the within 15 days, no? Within 15 days, until then, the NBW issued against him shall be kept in abeyance. The petitioner is directed to appear before the court and cooperate with the trial. So there you will be forwarded to custody.
Lot is directed to allow my bail period. Lot. Not how can it?
This is not a bail prayer, no?
Okay.
In terms of the above observation, this application stands disposed.
Also.
Petitioner is not represented. To stop this the matter after 1 week. He told you.
In this case, my lord, the judgment and orders of the learned courts below awarding maintenance, lords, have been assailed by the husband, the petitioner. Lord, apart from the other grounds which are on merits, those can be taken up later. But prima facie, my lord, the orders of the learned trial court as well as the my lord, the revisional court, my lord, they are bad because the maintenance has been fixed without the mandatory requirement of taking the affidavits of assets and liabilities. So, my lord, if your lordship will kindly come to the order of the learned magistrate, my lord, at page 35 onwards.
It was not considered.
No, it was not taken at all, madam. So, and my lord, I have a number of judgments of the coordinate bench. I will just pass on one judgment, you know, of so many judgments, but one I think will suffice. That the affidavit of assets and liabilities is a mandatory requirement.
Yes, yes.
So, my lord, in that view of the matter.
Not a new requirement. I think it's about 4, 5, 6 years.
Yes, yes. Rajneesh versus Neham. And Supreme Court has made it amply clear after that that it is mandatory.
Both the courts. The
Both the courts.
court also did not consider.
No. And in fact, my lord, there is nothing regarding any affidavit. I have made that specific statement.
In this manner, I can remand it.
Lordship
Take into
may remand it.
consideration.
Yes, my lord, I have an IE, my lord, that was actually for stay. But if your lordship is otherwise remanding it, perhaps keeping the challenge on merits open, my lord. Otherwise, it may be interpreted that perhaps that aspect is not. Because I have a argument on merit also. At this stage, perhaps only the or lordship may perhaps remand it and keep all the contentions open.
This case has been remanded back.
Yes. Lordship may remand it back then, my lord, to the learned trial court to begin at the stage from where the affidavit.
And even if you hear it after staying,
the
the
result will be same.
result will be same, and then this relief will be held back for a long time.
Yes, and in fact, I am very worried because the difficulty is in this case, this matter was actually the maintenance application was filed in the year 2014. And when finally the order came in 2023,
after COVID and all these years, my lord, the date of the application, from the date of the application, I have been asked to pay this huge amount. Now it is an amount in lakhs. I'm trying to pay and I'm paying. Ultimately, the burden on the husband is immense, my lord, in this case. So these aspects have not been considered and the affidavit has not been taken by any. So lordship may perhaps remand it back, my lord, to the trial court to discuss this aspect of the law. Because I am not referring to the judgments of the apex court, my lord. Those are referred to by the coordinate bench in the judgment. Lordship may perhaps.
Has been referred to, no?
Yes, my lord. Both the judgment.
Several cases, I have also remanded.
Lordship. Rajneesh versus
But
Neha.
that paragraph I have forgotten.
Yes, my lord, this paragraph also, I think it is referred by the coordinate bench. 64 and 65 of Rajneesh, my lord. Para 8 of the judgment that I have entered.
This court has referred to this judgment, Rajnish versus Neha.
Yes, but forgot the part where the. In fact, my lord, I must fairly say that the council also have a duty to point to the court that it is an ongoing matter.
Yes.
And I think both the
This
councils.
is, I think this came out in 21, I think.
2020, my lord.
20.
Justice Indu Malhotra's, yes. Indu Malhotra's.
Indu Malhotra,
Yes.
he penned the judgment, I
Yes.
remember. He has penned the judgment.
And 64 and 65 of Rajneesh, and as far as the other judgment of Aditi, my lord, Justice Vikram Nath's judgment, that is paragraph 14, 15, and 16. My Lord Justice Fukan has referred to specifically of these paragraphs and remanded the matter back, my lord, on that.
I can remind it, but subject to, where is your, where have you, in which part, paragraph of your petition have you mentioned about the,
Affidavit part, yes. I will come to that, my lord.
in which part of your petition you have
Yes, yes,
mentioned,
I will
which
just,
paragraph,
yes,
that this judgment has not been.
yes. Yes, my lord, this is, my lord, page 10, para H. But that the learned courts below failed to follow the binding direction of the Honorable Apex Court to the effect that a uniform format of affidavit of disclosure of assets and liabilities is to be filed in all maintenance proceedings by both the parties. The said applications are applicable since 4/11/2020, yet when the order dated 10/8/2023 was passed by the learned trial court, there is no compliance with the said binding directives, and hence on this ground alone, the maintenance order is liable to be successful. But paragraphs 11 and 12, my lord, in these terms of the judgment that I have just handed over, in similar terms, my lord, it may be remanded back because the payments are substantial payment has already been made by this petition.
Okay, this paragraph 12,
Approach.
that adjustment with the interim
Yes,
maintenance.
yes, 11 and 12. And my lord, one more thing, my lord, in this case, Ratan, that it was an interim maintenance. Here it is a final order. So both the
Final order.
it's a final order. Both the judgments are required to be set aside and matter is to be remanded back to the learned trial court in terms of para 11 and 12. Trial court will start from that stage because otherwise, my lord, it will be a difficulty, my lord.
DW1 has submitted documents,
Only the
Great.
salary slip.
salaries.
Only the salary slip.
Okay,
Lordship.
no point. It will, as it is, it will go back again.
Lordship.
Third learned counsel, Mr. A. Ganguly, for the petitioner, naam to niliki ba, who has filed this application under section 528 of the BNWS 2023 with prayer for setting aside the judgment and order dated 25/11/2024 passed by the learned session judge Sunitpur Tezpur in criminal revision case number 47 within bracket capital S hyphen 4 bracket close stroke 2023, whereby the judgment and order dated 10/8/2023 passed by the learned additional CGM Sunitpur Tezpur in MR case number 162 of 2014 was upheld and affirmed. The petitioner has been directed to pay an amount of rupees 10,000 as monthly maintenance to the respondent from the date of filing of the application. It is submitted on behalf of the petitioner that both the learned trial courts failed to follow the binding direction of the Honorable Apex Court to the effect that the uniform format of affidavit of disclosure of assets and liabilities is to be filed in all maintenance proceedings by both the parties. Full stop. The said directions are applicable since 14/11/2020, and yet when the order dated 10/8/2023 was passed by the learned trial court, there was no compliance with the said binding directives, and hence on this ground alone, the maintenance order is liable to be set aside. The petitioner has also relied on the decision of this court in a decision of a coordinate bench of this court in X versus Y, where in by order dated 7/2/2024 in criminal appeal number in এনেকে লিখিলে ভাল হ'ব RD versus SD লিখি দিবা তাৰমানে ইহঁতৰ ইনিশিয়াল কিটা RD versus SD where by order dated 7/2/2024 in criminal petition number 120 of 2024, the case was remanded back after setting aside the order impugned by the petitioner SD, RD, petitioner RD, that the petitioner and the respondent have not submitted their affidavit relating to their assets and liabilities before the trial court, before the family court. Full stop. It has been held by the it has been held by the Honorable Supreme Court in Rajneesh versus Neha and another reported in 2021 to SCC 324 that a judgment to the RD versus SD. Para 8 or 64 বুলি 64 or 65 কিটাই লিখিবা বাকিখিনি নালাগে হা para 8 or 64 তাৰমানে Rajneesh versus Neha পেহা 64 or 65 ইয়াতে আছে তবে ইন্টারনেটৰ পৰা para 64 I have scrutinized the decision of the learned trial court, which has been upheld by the learned appellate court, i.e., the learned sessions judge, Tezpur Sunitpur. Consider in the light of the decision of the Honorable Supreme Court in Rajneesh versus Neha and of a coordinate benches of coordinate bench of this court in criminal petition number 120 of 2024. I deem it appropriate to set aside the order impugned by the petitioner, full stop, a comma, and remand back the case to be discussed after both the parties submit their, what is this called? Affidavit, no?
Affidavit,
Affidavit of disclosure of assets and liabilities. So, in the result, the orders, the judgment and order dated so and so in criminal appeal number, criminal revision number 7047 S4 2023, date 2/25/11/2024, and the judgment and order dated 10/8/2023 passed by the learned additional session in MR case number 162 of 2014 is set aside, and both the petitioners are directed to appear before the learned trial court within one, both the parties are directed to appear before the learned trial court within 1 month and submit their affidavit of disclosure of assets and liabilities in the light of analysis assets and liabilities. Inform the no,
no, the learned trial court will have to issue notice to the
we will
respondent.
have
Yes,
learned trial court will
No, she's not here before us.
that the trial court will
But the-
petitioner is directed likhitla hobo, petitioner is directed to, and both the parties are directed to. Petitioner is directed to appear before the hearing, petitioner is and both the parties are directed to submit their assets and liabilities. In terms of the above observation, this anything else left out?
No, the assets and liabilities, and thereafter the matter shall be heard, because
Yes,
the matter has to proceed from that stage onwards.
and thereafter the matter shall be heard by the learned trial court after considering the assets and liabilities submitted, disclosure of assets and liabilities submitted by both the parties. In terms of the above observation, this application stands disposed.
One last indulgence, Manoj.
Yes,
Para-
yes.
In terms of para 12 of Justice Fukan's
Okay.
judgment, that part.
Which one?
Manoj, if any, the payments made by the petitioner, Manoj, since we have made payments, Manoj, that
Okay,
may be
okay.
adjusted.
If any payment already made by the petitioner, in view of the impugned order, the same has to be adjusted against the order to be passed on maintenance.
On maintenance.
Officer in terms of the I do have likhini I to dispose of retained. Any other submission, short, very short, for adjournment, for adjustment, anything? Others, I'll come back after break.
Regarding item number 16, your lordship, last chance was given in the next last occasion, your lordship.
Okay,
And
they are not here.
at two,
Not sight of them since morning, not one single junior also.
oh, yes, your lordship.
Item 16.
16, yeah.
Yes, ma'am.
You're here.
Yes, Lordship. Lordship, my senior is on the way. He'll be here at 2 o'clock. If you would be so kind as to
Very
take the
good,
matter.
very good. Good enough. Because she is always raising objection against your non-appearance.
So I have a small submission in item
Obliged.
27 and 28,
Ah.
the connected matter. In that matter, we are it's a first appeal. This matter, we are challenging the judgment and decree dated 29/10 to 2022, passed by learned civil judge Jorhat in manuscript number 2 of 2024.
Item number?
27 and 28.
Okay.
The connected matter.
Yes.
In this first appeal, I am the plaintiff. In item number 27, I am the plaintiff. And in item number 28, the defendant is the appellant here. In item number. But we haven't received the copy, so we have to exchange our copies today.
So you'll take adjournments.
I have talked with the council that he will provide me a copy of the petition appeal in item number 28. And similarly, in case of item number 27, I have to provide him the copy.
Okay. You provide your copies and then we will fix this matter for admission.
Lordship.
Okay. As agreed by both the parties, list this matter, both the parties, okay?
Lordship.
list this matter for admission on.
Yeah, as per
After this, you will place your submission on admission, no?
Lordship.
Or you want to place it today?
No, Lordship, actually you have to exchange the copies.
Yes, yes, of course. 25th June, 27 and 28.
Yeah, Lordship, 27 20.
I'll not write all this copy changing and all.
I have come on the ground, my lord, new ground of my lord, his wife being pregnant, my lord. Your lordship will kindly come to page 46, my lord. The medical report. He's a government servant. He's a community health worker. His ID is at Annexure 1. And my lord, page 46 is a certificate from the attending physician.
Oh, that person who was assaulted for stealing.
Yes,
pencils.
yes.
Yes, my lord. Victim was at that case, man.
Oh, I have granted bail, no?
To the regular
Regular
bail to the other two accused.
Oh.
And
Who were the main accused, man? In fact, he was not the main accused.
is it anticipable?
Oh, let us call for a CD.
My lord, only one thing, my lord. Huh?
No, no, no.
No.
No, I have gone through the CDA. No, no, no. I'll not give interim protection. I'm really sorry. I'll call for a CD.
Then, my lord, a short death
Sure.
from Rota only.
Call for the CD, list the matter of.
And I am also facing, my lord, on the other side is, I'm a government servant facing suspense. Show cause notice has already been issued to me now.
16/6.
That also I have annexed, man. Till next date, my
I've
lord.
seen the CD, no? I've seen the CD.
But the main accused, my lord, if your lordship will recall, my lord. Anyway, let the CD come. Obviously, your lordship will go through it. Till next date, my lord, interim protection.
I'm really sorry. I'm really sorry. He was bludgeoned to death for stealing only little bit of tamul. And then there you have a case, good case for acquittal, maybe, I don't know, according to you, but very protected.
Item number 16 and
There
17.
there was a huge mob, my lord. That is on record,
No,
very clear.
no mob. Only these family members.
No, they have stated, my lord, in their own documents says.
Maybe.
Their documents say.
Maybe.
Large gathering of public. And that was
Public
about
is
11.
but assaulted by 4 or 5 only. Assaulted by 4 or 5 only.
16/6. Not something.
Look, there are two petitions. One is transfer petition criminal 29/2019 and one criminal petition for quashing of the domestic violence proceedings that was pending in Obhayapuri.
Your lordship, may I have one prayer, your lordship?
My lord, I am the petitioner. She should not be so anxious about this case.
Regarding.
I'm observing at her. On last occasion, I was severely sick. For the safety of my other friends, it was a viral fever on me. I took an adjournment on my health ground. Tomorrow she may be at the receiver's end. Today at 1 p.m. she made a mention, not looking at me in this courtroom, that I am not in the court. No, I was traveling from Nagaon. I went to Nagaon and 7 a.m. in the morning, did a case there at 10:30 and rushed to Guwahati to attend this case. No, my lord, there is a limit of everything. I am practicing this court last 20 years with high head. No, my lord, I'm so sorry to say all this.
Okay,
Tomorrow she may be at the receivers then, my lord.
It's okay.
No, she should not disturb me
No, just
while I'm arguing this case.
Maybe it will cut short.
Yes, of course.
Item number 17, when service is not complete. That's why this matter cannot be taken with item
I am
number 16.
coming, I'm a responsible officer of
That-
this court. I am
that-
going to
that is my prayer, your lordship.
apprise this court on this point even. I have taken note when the steps was taken. Steps was taken in the year 2019 itself. There is no order from the Lawajima court whether notice is served or not. There is no order from the honorable court deeming it as a served notice or not. I'm coming on this thing. Why?
Item number 17, 18, 19 or 17 and
No,
19?
no, 16, 17.
16 and 17.
16 and 17. Okay, so
She said we have taken 24 adjournments. Sorry, my lord.
regarding to item number 17,
Service is not complete.
Let us come to the first matter, my lord. I will come to the
everybody
second.
has a right to place their case. Maybe
I understand,
you
my lord.
might have taken 24 adjournments.
No, I understand, my lord, but there is a limit of something. So,
Respondent number 2 service of notice on respondent number 2 is not complete.
Yes, and I cannot appear in that matter, your lordship. This is
you
legally
are not
matter.
praying that
Let-
she should appear.
I am appearing on behalf of as legal aid counsel, your lordship. I have been allotted with the item number 16 only.
I'm aware
And
of
that
this.
is their discrepancy, and they will allot someone, one legal aid counsel, and I cannot directly appear. And he has tagged this matter, item number 17, where service has not yet been completed.
All right.
That is
Then-
my
Now,
prayer.
lordship will take up the transfer matter today, for now.
So take up item number 17 then.
Yes.
Well, lordship will pass
Item
definitely.
number 16, your lord.
In item number 16, lordship will
I am-
definitely pass an order placing the matter before the lower Zimma, or we may be allowed to take a fresh steps, whatever, on that matter. But this today,
But
item
cannot, because the item number 16 is for hearing, and that one is service is not yet to complete, your lordship. Item number 7, how can it be possible, your lordship? A matter that is ready for hearing, and in another matter where service has not yet been completed, how they can be.
now let her
taken-
suggest what to do. Let her
I have no
suggest.
idea regarding item number 17, your lordship. I
So-
have idea
So,
regarding
ma'am,
item number 6.
I am advising this court what to do.
So this arises out of the same cause of action.
Same cause of action, my lord, same domestic violence proceeding. I have the item
The
16.
other part is BD core, isn't it?
Earlier it is filed by Association
Bidikwa.
Counsel Mr. Bidikwa. Now it is a transferred brief to me.
But here the name of BD core appears only.
Yeah, my name is also appeared.
Huh?
Milord will straightway come to page 15 of the transfer petition. In last occasion, it was submitted and it is reflected in the order of the dishonorable court that lady is a very poor lady, does not have even financial capacity to manage 2 square meals.
Maybe. I can't.
That no, it was submitted. That is why your lordship recorded.
Mm.
My lord, this poor lady has a wine shop and 3-4 RCC buildings, and she purchased the quid cars by paying in cash in her name. We have annexed everything. Also, she does not even pay for maintenance in the DV case. Also to your lords. My lord, there was a civil divorce proceeding pending in the Kamrup Metro. My lord will take a note of this. That divorce proceeding was initiated by me as a husband. She filed a transfer petition seeking this matter to be transferred from Kamrup to Obhayapuri, her mother's place, her parental place.
Okay.
That judgment, that transfer petition was disposed of by this honorable court, a coordinate bench. That judgment is at page 15. This is important first. May I read below. All observations is as regards this lady is here.
এটা বন্ধ করে দেওয়া যাবে?
The present petitioner
Hmm.
was acquitted of the offense under 138, but later on, the petitioner of your lordship was directed to go simple imprisonment in default of payment. The factual matter is, lordship, the present petitioner of your lordship is the retired principal.
But he was acquitted, no?
He was acquitted, but in default of payment, he was to go to simple imprisonment. Only for that extent, lordship, the petitioner approached this honorable
That
court.
means he was convicted to fine maybe.
The lordship may peruse the entire judgment need not be lordship. Page 20, lordship. Page 19, lordship. Or page 20, paragraph to 28, lordship. Internal page number 12.
Okay.
Yes, Lordship. May I read Lordship? Paragraph 28, Lordship.
Mm.
Considering the evidence on record, accused number 2, so and so, and accused number 3, that is the present petition of your Lordship, are accordingly acquitted of offence under section 138 of NI Act and set at liberty forthwith. Their bail bonds further extended for 6 months. On appreciation of the testimony of witnesses and the materials available on record, I find accused number 1, so and so, liable to for commission of offence under 138 of NI Act, and accordingly I hold the said accused number 1 guilty of guilty under section 138 and convict thereunder. Considering the nature of the offence and the other attending facts and circumstances of the case, I am not inclined to extend the benefit of provision of section 4 and 5 provision of offence 1958. The accused number 1, so and so, is sentenced to a fine of rupees so and so, that is a check amount, and in default of payment of fine, the present representative of accused number 1, that is the principal secretary, accused number 2, and that then representative of accused number 1, principal secretary, accused number 3, so and so, shall go simple imprisonment for 3 months each. He was the retired principal, Lordship. So my only to respectful my submission, Lordship, he have issued the check not in his personal capacity, but in the capacity of principal secretary, and a check was issued in the month of December, and the check got dishonored in the month of March. So, Lordship, the present petition of your Lordship is nowhere connected with the offence, and to that extent, Lordship, this honorable court has earlier passed a judgment, which is I am sending to your similar with similar facts and circumstances, Lordship. Similar facts and circumstances.
Principal secretary of which institution?
Uttar Compete College, Lordship, Jagra. Arising out of, Lordship, here the order upon which I am relying, Lordship. This order is also filed by this present this revision petition also filed by this present petition of your Lordship, and only the complainant in the NI case is different. Other parties are similar, Lordship. Here, Lordship will find the order. If may I read it once, Lordship. The order dated 19/3/24, which I just now handed over to your Lordship. May I read it, Lordship? Yes. Heard so and so, line counsel from appearing for the petitioner, also heard so and so, for responding respondent. This is an application under section 397 of CRPC, reduce 401 of the court challenging the impugned judgment and order dated passed by CGM Nalbari. In NI case number so and so, the petitioner so and so, referred as the petitioner, was the principal of the so and so situated at Jagra. On behalf of the state college, he issued a check of rupees so and so to the respondent 1, who supplied some materials to the college. The check was issued on 30/12/2024, and on that day, petitioner retired from service. The check was dishonored by the bank. Therefore, the respondent filed a case under section 138 NI Act against the college and its present principal and the petitioner. The trial court acquitted the present petitioner from the offences under section 138. The Uttar Compete senior Jagara was convicted and was sentenced to pay fine of rupees so and so. The trial court directed that in default of payment, the present principal of the said college accused number 1 and the present petitioner shall undergo imprisonment of 3 months. This is the reason why the present revision petition has been filed. The question that is raised by the petitioner is that once he is acquitted from this case, why he is made liable to pay the fine. So Mr. So-and-so submits that instead of filing this revision petition under section 3 so-and-so of CRPC, the petitioner should have filed an appeal before the session court. According to Mr. So-and-so, since there is a provision of appeal before the court of session, the petitioner under section so-and-so is not maintainable. Mr. So-and-so, on the other hand, submits that since the trial court has committed a mistake in law, this court has jurisdiction to enter in the revision petition so-and-so. I have considered the submissions made by both the sides. So paragraph 11.
The side.
Lordship, name has been shown in the cause list, Lordship. But they did not appear. On last occasion also, Lordship,
they have not appeared.
The matter could not reach, Lordship. I was there, but they did not turn up. I personally know him. I tried to contact him, but his phone is switched off. He might be here since one Pratik Mazumdar was engaged earlier. but his number, he have changed his number.
Item number 18 and 19.
Yes, Lordship. In 18, Lordship, name has been shown.
For both the cases.
In 19, name has not been shown, Lordship. In 19, name has not been shown. I suppose in 19, he might not be there. I am not very sure.
Let me check.
Yes, Lordship.
We have the LCR.
Yes, Lordship. LCR also called for, Lordship. And difficulty is, Lordship, then the.
No, this is already disposed of, so LCR is called.
Yes, Lordship. The college authority has also filed an appeal before the learned session judge Nalbari. And the appeal cannot be proceeded because of pendency of this revision, Lordship. This is the difficulty, Lordship.
Service of notice is complete on all respondents.
Yes, Lordship.
They're not represented.
No.
28/8/2024.
Sorry. Lordship, may I read the paragraph?
No, you have a case, good case. But we have to hear the other side.
If Lordship, they did not appear, Lordship, though.
We'll give them one last opportunity for
Yes,
interest of justice.
Yes.
One last opportunity. You have a good case.
Only thing, Lordship, I am old aging person, Lordship. So because of the pendency of the cases, Lordship, I am convicted. I am yet to receive my pensionary benefits, Lordship. That is the I have some. Otherwise, I am.
One short date. One short date.
Yes, sure. Yes, sure. Otherwise, Lordship, there is a stay. I have nothing to fear. But still, it will be.
You want the pension. It's very
Yes,
important.
yes, Lordship.
Eighteen of Likhazo. Learned counsel, Mr.
SN
Krishnotria, no?
Yes, yes.
SN Krishnotria is present for the petitioner. The respondent is not represented today, but the names of the learned counsel for the respondent appears on the cause list. A last chance opportunity is accorded to the respondents to place their submission, failing which necessary order may be passed. Please the matter on. Etu eke likhi diba. Third learned counsel, Mr. SN Krishnotria, no?
Yes, SN.
For the petitioner, the respondents are not represented, nor the names of the learned counsel for the respondents are reflected in the cause box. LCR is received. It is. Office note dated 28/2024 indicates that notices have been served to all the respondents. And this court by order dated 28/8/2024 has also observed that notices have been served to all the respondents. Then whether they are represented or not, we will fix it.
Yes, yes, sir.
However, the respondents are not represented today. Please this matter for admission. It will check for some person date. Notice to office note of likha ase serve hoise boli aru bench ro order ase serve hoise boli tabi ebar check koriso. Item number 17, 18 asile na?
18 and 19.
18 and 19. 19 to chapa ha. Serve hoise boli likha karo. Serve hoise boli likha. Okay, let's just matter date or date. 23rd June.
Yes, sir. Deeply obliged.
Then we will finish.
Yes, sir. May I take back the order or Lordship?
Oh, yes, yes, yes. That's going to be the. I think 21. 20 given. Oh, 20.
I'm appealing for the respondent number 2, Your Lordship. The trial court as well as the appellate court has convicted the petitioner and sentenced him to undergo imprisonment for 6 months and to pay a fine of rupees 11 lakhs. This is with respect to a check, Your Lordship, which was dishonored. The amount is 10 lakhs and he was directed to pay 11.
You are a
lakhs.
respondent.
I'm for the respondent number 2.
What
Your Lordship.
happened? What is?
They're
What
not
about the
appealing, Your Lordship.
petitioner? One party is present, the other party is absent. You are the informant,
I am the complainant.
complainant, and he is the accused.
Yeah, he's
I
the
think
accused.
he has got a stay.
No,
That's why
no,
he's
Your
not
Lordship.
for us.
No, Your Lordship. In fact, they have not only paid the 20% as required under section 148, Your Lordship. That order is also not there.
20% also he has not,
Not paid, Your Lordship.
no stay, no?
No stay, Your Lordship.
Good for you.
No, I'm the complainant, Your Lordship.
I know, good for you. You'll get the money then. He's willing to pay it, it appears. For interest of justice, one more date, last
Yes.
date,
That's it also.
revision petition, others will have to dismiss on merits.
Deep progress also.
Petitioner is not represented, although the names of the learned counsel for the petitioners are on the are reflected in the cause list. Learned counsel Mr. T. Devi is present for respondent number 2 and learned additional PT Mr. D.P. Swami is present for respondent number 1. For the interest of justice, list this matter positively for admission on the next date fixed, failing which necessary orders may be failing which nalaya fixed full stop. On appearance of any of the parties, necessary order may be passed. 24 June.
Deeply obliged, Your Lordship.
My lord, in this case, my lord, on several occasions, my lord, on 3-4 occasions, my lord, case there was called for. It's a case for quashing on the FIR, my lord.
You have the
The
CD.
case they not received lordship, so give us last chance, sorry, I will produce the case.
One last chance.
One last time, your lordship will direct them, my lord, to produce. Otherwise, my lord, this is very near, my lord, wall to see.
We have
It's very-
communicated in last on 16/5/25 also.
Others will proceed without the case diary.
Yes, my lord, there is no ground, my lord.
Okay.
Baseless allegation in the
If I
FIR.
then also shorted, I will produce.
CD as called for is not received. The prosecution is accorded a last opportunity to produce the CD. List this matter on for CD positively. Take the leave.
Obligation.
Item 23.
My lord, on the last occasion, lordship will see 19/5/2025 updated status report was called for
23, no?
from the Dispur police station.
Lordship, up to date CD is yet received, but Aditi is not up to date. Lordship. After status report and case diary, that is not received yet. Is the CD is updated on 14/11/22.
14/11/22.
They have
Updated CD
At least an updated status report may be called.
14/11/2022. What is going on?
They have taken back it and send it SMS.
2022.
Lordship,
This is relating to what?
But this is in POXO case.
Quashing of this case, no? Investigation is still going on.
investigation is still going on.
Investigation is probably going on, but I am not the named accused. There's a
You are granted stay?
but
Any
I am on
connection?
regular bail. I am on bail.
Or regular bail, okay. You are on bail. Learned counsel, Mr. A.
A.
is present for the petitioner. Learned counsel, Mr. G.D. Gogol is present for the respondent number 2. And learned additional PP, Mr. D.P. Goswami is present for the respondent state and Omar. Full stop. Learned additional PP has submitted that the CD is not up to date. send back the CD, call for the up-to-date CD positively. Send back the CD, call for the up-to-date CD, post of the CD has to be positively updated on the next date page along with the status report,
Status report, yes.
along with the updated status report of the investigation.
Yes. This is dispute police station, so short date may be given.
Yes,
Dispute
can be.
station,
This is the matter of
18th June. Obliged matter.
Yeah, in this case, the matter relates to 145 proceeding lordship. And for that complaint, your lordship will find at page 14, starts from page 14 and relevant portion page 15. So may I read the first of it? That the petitioner first party is a poor helpless daily wage laborer without having money and muscle power, peace loving and law abiding person. On the other hand, the second party are very powerful, influential, law abiding, litigation loving and greedy person having money and muscle power. Being powerful and influential persons in the society, the second party never hesitate to commit any unpleasant incident in the society at any moment. The people of the society are scared of them. And if somebody raises any protest sometimes against their misdeed, the second parties immediately implicate such person in false criminal or police case and thus harass him, her both financially and mentally. Under such circumstances, last year, the first party bought some land situated adjacent to land white registered sale deed number so and so. The first party got the below scheduled land by way of inheritance from his father, who got the land by deed number so and so, so and so. So Lordship may kindly note the date that is of 1956. And by way of purchase by registered sale deed number so and so dated 64, 56 and 64. And had been possessing and enjoying the same till date.
Somebody got the land separated, sale deed number. This 17/5/2013.
No, that is the adjacent land. So he is not speaking about the disputed land in that case.
Oh.
Disputed land, he
This
is
is
speaking
inherited from his father.
father.
And the father bought the deed on.
Did in the year 1956 and 64
Ah.
respectively. And had been possessing and enjoying the same till date by way of cultivation without any objection or hindrance from any quarter. Paying revenue thereof to the government government year after year. No dispute has been arisen with regard to the land. Like previous years, this year also, the first party has cultivated the below scheduled land with some other lands. But in the morning yesterday, that is on 15/6/2014, when the first party went to his land for tiling it, the second party is armed with dao, lathi, spear, etc., resisted the first party from tiling the land with a threat that they would kill him. Though the helpless first party raised the matter with the local elders for bichar, the second party are still trying to dispossess the first party from his below scheduled land by uprooting the boundary pillars of their land and affixing the same on the land of the first party. So here your lordship may kindly note that he informed the other local village elders, nobody was interested. And second thing your lordship will see that he is saying that second party are trying to dispossess. So he was not dispossessed according to him, lordship.
Okay.
The second parties have also been declaring before the others that if the first party goes to the below scheduled land, they will kill him. The first party is a poor and helpless person having no money and muscle power. And on the other hand, the second party are powerful and influential persons of the society having money and muscle power. Hence, the second party may dispossess the first party. So may dispossess from his below scheduled land at any moment, taking the helplessness of the first party. And therefore, there is possibility of breach of peace and tranquility in the locality.
Okay.
So this is the complaint. Now, lordship will find that on the basis of his complaint, Lordship, that the learned additional district magistrate took cognizance of the issue, and Lordship will find that order at page 24 that the land was attached, page 24. And police report was called, Lordship, page 24.
Yes.
And on getting the notice, Lordship, the petitioner appeared before the additional district magistrate and submitted his written statement that your Lordship will find page 25. Now, this is important, Lordship may kindly see, because on the basis of this written statement, that order was withdrawn. The earlier order was withdrawn subsequently under 150. That relevant paragraph, Lordship may kindly see, paragraph 2 of page 25. It may be worth mentioning over here that neither on 17/7/2024 nor today either the police or the first party member has submitted any information before the court showing that likelihood of breach of peace regarding the subject matter of the dispute at the locality. And on this score alone, the attachment need to be vacated. Then para 4, Lordship may kindly see, the second party member, Mohammad Alam Hussain Borbuya, begs to state that he had purchased the disputed land and other adjacent land by getting a deed of sale executed and registered on 15/5/2013 and 17/5/2013 by one Mohammad Azizur Rahman Borbuya. So the case was that the complainant, Lordship, he sold the land to Azizur Rahman Borbuya, and from Azizur Rahman Borbuya, the petitioner has purchased. And in fact, the complainant also filed one case under section 145 against Azizur also. He was in actual possession, physical possession over the disputed land and other contiguous land from long before such purchase, and cultivated and harvested the concerned paddy land twice a year till the last occasion in 2013, that is after such purchase. The vendor of the said title deed had the absolute right, title, interest, occupation, and possession over the entire land, including the disputed land. Before such sale, the said vendor's claim had faced objection by one Muhammad Abdul Quddus Borbuya and others, which has finally disposed of by said D. Chakraborty, Daden ADC Kachar on 22/4/2013. That is what I have stated. That earlier also he filed one complaint against that Azizur and others, 145. That earlier from whom I have purchased the land. Because he is not going to civil court, because he do not have any documents to show, prove his title. So he is filing this 145 proceeding one after another against the person's Lordship. In favor of the said vendor, and then LC and the LS NOC was issued by the collector on 4/5/2013. So after verifying all the documents, those NOCs were issued. It may also be mentioned over here that the said objector had filed a complaint under section 144 CRPC against the said vendor on
You submitted just now.
10/12/2012, and then the said vendor had submitted his reply on 20/12/2012. And finally, the Sonai PS on inquiry had submitted its report on 26/12/2012, reporting that the complaint was baseless. Then your paragraph 8, Lordship may see, the said second party has also submitted a complaint under section 107 CRPC against one Abdul Aziz Borbuya and others on 30/6/2014, and the same is under inquiry. Be that as it may, the said vendor of the said second party had purchased the present disputed land from the present first party member and others by a registered deed under dated 6/12/1993. So this was informed, and accordingly one order was passed that your Lordship will find at page 32.
That attachment order was withdrawn.
Withdrawn. And there is one Lordship line which is in my favor, so I am pointing out the second paragraph, Lordship. Initially that background of the case is there in first paragraph. In second paragraph, your Lordship will find page 32.
Okay.
On perusal of the relevant papers, documents, and on hearing both the parties and their engaged learned lawyer, who have neither in writing nor verbally stated about the apprehension of breach of peace over the matter at present. So at that point of time, that is on 21/7/2014, this order was passed. There it is said that there was no breach of peace. And in the final order, your lordship will find that it was observed that there was breach of peace, but no police report or nothing new documents was entertained, lordship. On the basis of what evidence that finding was recorded, that is not there. Since disputed land is cultivable land and period of cultivation is passing out, so I am of the opinion to withdraw the attachment order dated so and so forthwith. So this was withdrawn. Now your lordship will find page 33 onwards. These are the sale deeds. That Azizur Rahman and Saidur sold those lands to other persons. And just I'm referring to page 44, lordship may kindly see. Page 44.
Yes.
Serial number 5, that is name appears Aftabuddin Mozumdar, second party. That is the respondent number 2.
It's 39 also, no?
Yes.
Who is this person?
This is that Azizur Rahman Borbia that I have met.
What Saidur Rahman?
That Saidur Rahman and Azizur Rahman Borbia. Azizur Rahman from whom I have purchased. That my names appear subsequently, I am showing that. But in this document, your lordship will find that the lands which he is claiming, initially I am not disputing that it was his his father's property. Subsequently, they sold it and to Azizur Rahman. And Azizur Rahman sold it to various persons, lordship, including me. And that your lordship will find page 44. Your lordship may kindly see.
When this was withdrawn,
Lordship.
so you are aggrieved now.
No, subsequently after withdrawing lordship, that my learned engaged counsel could not appear, and on the other hand also that additional magistrate has to satisfy that whether there is chance of breach of peace or not. No, nothing, no report was
Not finally decided.
not finally, and there it was observed that there was breach of peace. So
You are against which order?
against the order of district magistrate and the order passed by learned session additional session.
District magistrate, which order?
Page 62.
Page 62.
62. And in page 62 also, lordship will not find any reference to police report. And the documents which are submitted, nothing is mentioned.
This is the final order passed by the district magistrate.
District magistrate.
So you are the first party.
I'm the second party.
You are the second party.
Second party.
Alam Hussain Borbia.
Lordship.
And this is the first party.
First party.
Aftabuddin. So he first party was declared as the owner and the possessor of the land.
Possessor of that.
Not the owner.
Because lordship, my main contention for lordship is that when there is dispute between two persons, individual person, then 145 proceeding cannot go, lordship, because the additional district magistrate assumes jurisdiction only when there is dispute between two groups regarding any land, water, or anything, lordship. There has to be dispute between two groups. That part is missing, lordship. This entire dispute is between two persons.
And district judge's order upheld this order.
Upheld this order. And in fact, your lordship will not find that in 2014, the additional district magistrate withdrawn the order, earlier order, by saying that there was no breach of peace. And on what basis, on what material he come to a conclusion that there is a chance of breach or he was disposed?
This evidence been recorded?
Yes.
Evidences were recorded.
My evidence is recorded. He did not appear. So ex parte.
Evidence is recorded, no?
Evidence recorded, but my only prayer before lordship was that initially he submitted those documents. There has to be some material to show that these materials were not correct. And on the other hand, also lordship, that ex parte order, I'm also relying on one judgment of Honorable Apex Court where it is said that negligence of advocate, that party should not suffer, Lordship.
Okay.
Because if he has, because otherwise if he Lordship the owner of that land, he could have gone for the civil suit, but in spite of that, he has not gone.
See,
And
you
today,
you
Lordship,
did not appear your, it was decided against you. So where is your ground? You want an interim stay?
no, already stayed. It
got a
is
stay.
already stayed.
Already decided
Already,
against you,
yes.
So
Already
what
stayed.
is your prayer now?
My prayer,
Admit
Lordship,
it or I'll dispose it finally. This is
No,
the
decide, because he
admission
has
stage or hearing stage?
My lord, he has already obtained a stay from this honorable court.
Yes.
Okay, so now, my lord, I may pray that your lordship may decide the matter. If
This is
it
at the stage of admission.
is at the stage of admission, madam.
All right.
Here,
Anything else?
here, Lordship, I have two prayer. Lordship is concluding today or Lordship will hear other day? Because I have to submit more.
Definitely I'll conclude it today.
Lordship,
Why already have wasted enough time.
Lordship,
In the beginning of this afternoon session,
Lordship,
I have heard at length and then nothing came to a conclusion.
Lordship. No, Lordship, I can keep it part. I have nothing to say because I have to submit those judgments on the point, Lordship, because
Yes, I can leave it as part.
that
Okay. You want to submit judgments?
judgment.
You won't submit it today.
Yes, I will submit it today, Lordship, but I have to read it out and point out on what point I am relying on.
Yes,
Because
you
of
can
that.
read it out and point it out.
Lordship.
What will happen to everybody waiting behind Mr. Ahmed? Should I?
Now, if there are bail matters, my lord, in that case, my lord, we will not. Because this is not a matter which we will require. If there are no bail matters, my lord, then your lordship may conclude. Otherwise, if there are bail matters, my lord may keep it as part of it.
Exactly.
Because your lordship has also had a very long day. So if
No,
you're
it's okay. I can continue today. I am fit.
because I will not take much time.
Yesterday I was not fit. Today I'm fit.
Because I will not take much time. Only time perhaps will be required by him, my lord.
Yeah, it looks like.
If it is, if your Lordship, it is remanded back and he is not arguing much, then I also have
I
to
will
think,
not
sir.
pray for remanding back, my lord, because we have a case. We have won the case fairly, my lord, by adducing evidence. And
Yes,
points I
yes,
will counter,
true,
my lord,
true,
whatever point,
true.
my lord. Sir.
No.
There he has admitted.
No, that,
and there
that part I am not saying, Lordship. But
participated in
one
the
aspect
case.
your Lordship has to see that Honorable Supreme Court and our High Court also clearly says that if there is no chance of breach of peace, then additional district may have no jurisdiction.
That will
If that
have,
goes, the order goes.
That will have to scrutinize.
Yes, that your Lordship will see. Because I have that sale deed also, everything document I have placed before that court when submitting WS, Lordship. At least those documents has to be appreciated. Because no for new documents has been appreciated.
Yes, anything urgent?
Lordship, I keep it as
With big apology, my lord, item 47, I am afraid it will not reach. My
Sure,
bail,
it
in
won't
IAM, my bail is up to today, so it may continue, my lord. That is.
Just a moment. Huh?
Honorable Court, while admitting the appeal, bail was granted till today with a notice to the parents. And punishment is 3 years. So I may enjoy the benefit of the bail also, my lord.
Punishment was for 3 years.
Yes. But since this was the POSCO case, court has directed to send a notice to the father, and it was given from the registry. We have also served, but they have not turned up.
Hey, notice service and use also?
Notice it was sent on 6/5.
6-5 years. Notice issued.
So it is more than a month, my lord. It is
Respond number 2 to OC.
Though AD card has not reached.
Okay, we'll extend it then.
Extend.
Learned
Further-
counsel, huh?
Further, my lord. It
Okay.
may take further.
Learned counsel, Mr. S.C. Biswas is present for the applicant. Service report of notice on respondent number 2 is awaited. Learned additional 50, Mr. D.P. Biswas is present for the respondent's state. As an interim measure, the applicants are allowed to remain on previous date, shall continue to remain on previous date. Till July, on July, in the month of July, he is on interim bail, no? 14 July. I to. Main case to main case ঠিক আছে main case একে লিখি দিব খালি বেল টো এক্সটেন্ড কৰিছে বুলি নিলিখিবা ৰেকৰ্ডটো আহিলে সেইটো তুমি চালা তুমি নটিচ চাৰ্ভ হৈছে নহয় নহয় মই চেক কৰিব কৈছো যে তোমাক সেইটো যে হৈছে না চাৰ্ভ হৈছে না মানে অফিচ নোট মতে আছে কিন্তু মই চেক কৰি চোৱা নাই এ বি বি লগত চাৰ্ভ হৈছে না তুমি চেক কৰি চাবচোন Yes, yes.
Lordships are likely to take up the other matters, or lordships will not take up any other one? Because otherwise my matters, the next matter, there's no urgency as such, but the only difficulty is that the interim order was till Wednesday last, lordship. Lordship could not sit on that day. If the interim order is extended, I have no difficulties. 25 lordships. My
extend to do interim order.
Urgency, he has no difficulty. Lordship will take it up in July sometime. There's no urgency in the matter per se. 21st July, perhaps.
Lawyer counsel Ms. R.S. Chaudhary is present for the
petitioner.
Appellate petitioner. Learned counsel Mr. T. Devrina
Yes, sir.
is present for the respondent.
Number 2.
Number 2.
As MI consults.
No, sole respondent.
Sole respondent is present for the respondent. Interim order shall remain in force till the next date fixed. List the matter of 31st July. Just a moment. Anybody else? Anybody?
It's not been.
Not bail, no?
No, it's not been. It is revision.
Lordship, I am for the sole respondent, Lordship. Copy not furnished to me, Lordship, in this case.
এইটো কিবা থাকি গল petition টো আছে এইটো কেছ এইটো কি আছে
Item 30.
We'll finish your case today. Everybody is accommodating.
Two judgments I will have to place. So that is placing. My item is 10 minutes, 10 or 11. My
10 or 11.
item 30. It is very short matter.
30. Learned counsel Mr. A. Rashid is present for the petitioner and learned counsel Mr.
M. Hussain on behalf of A.J. Ahmed.
M. Hussain
Lordship,
on behalf of
A.J. Ahmed.
Mr. A.J. Learned counsel Mr. A.J. Ahmed is present for the respondent. So it is submitted that the petitioner, that the respondents have not received copy of the petition. Petitioner to furnish copies of the petition to the respondent.
Well, I'll post the way I'll tell.
Lordship,
12 minutes. It was 12 of June.
12th of June.
12th June. It is very short matter.
List the matter on 12th of June.
Lordship, engaged counsel A.J. Ahmed, he filed the wakalatnama, but his name not shown in the
Receipt to reflect the name of engaged counsel AJ in the cost list as he has already submitted wakalatnama. Yes.
May I please the lords, my lord, item number 44, my lord.
Yes.
It is a competition and condonation of delay, my lord, 86 days, my lord. And it is filed in the year 24, last year, my lord.
You will issue notice?
Yes, my lord, notice is issued and service most probably it is completed, my lord.
Criminal
Yes,
case?
I a criminal, my lord. It is an appeal against acquittal, my lord, and there is a 86 days delay, my
The
lord.
accused has appeared. Has notice been served to the accused?
No, notice is served, my lord, to the respondents, my lord.
Respondent is the accused, no?
Yes, my lord. Respondents, my lord.
You are the complainant who is against appeal against acquittal.
Yes, my lord. I am for the complainant. Informer.
I'll just check, just a minute, huh? 3-6, service report for respondent number 1, 2, 3, 4 has not been received. Awaited. You have to await. He's an
So-
accused, no?
That may be
Service
conditions.
report on petitioner is represented by learned counsel Miss B.R.A. Sultana. Correct, no?
Yes.
Service report on respondent number 1, 2, 3, and 4. 4 respondents
Yeah,
is awaited. List the matter when we want.
in the month of June, my lord, any short date.
29 June,
23rd
okay?
June must have been.
Let the others remain left over. I'll have to hear him also.
No, yes, no.
Because while giving date, I won't be able to hear him also.
Okay.
Huh? Left over? Hope you won't mind.
No, no.
Anything urgent?
No,
Not
no.
urgent, no? Okay.
My lord, may I, in item 51, there's a delay of 4 days, my lord. So that may be condoned, my lord.
This is criminal appeal or
Criminal appeal, my lord.
criminal? PP.
Yes,
It
only
will be
this
condoned. Did it will be video.
51.
PP won't raise objection till 100 days. Their limitation starts after 100 days. I to liaison learned counsel Mr.
Yes, they, my lord.
S. Day is present for the applicant who has filed an application under section 5 of the Limitation Act 1963 praying for condonation of delay of 3 days.
4 days, actually.
Delay of 4 days in preferring the connected appeal against the impugned judgment and order dated 2003 passed by the learned Special Judge Lakhimpur, North Lakhimpur in sessions case number NDPS in special NDPS case number 10 of 2022 convicting the appellant under section
My lord, he was convicted under 21B, my lord.
21B of the NDPS Act and sentencing him to undergo rigorous imprisonment for 5 years and a fine of rupees 10,000 with default stipulation and further and further convicting the appellant under section 29 of the NDPS Act and sentencing him to undergo rigorous imprisonment for 3 years and a fine of rupees 5,000. Heard Mr. D.P. Goswami learned additional PP Assam. It appears that delay was not intentional. Sufficient grounds have been shown. Considering all aspects, delay is hereby condoned. Registry to register the connected appeal. All right?
Lordship. Much obliged.
I stands disposed of.
Lordship. Lordship, item number 48, Lordship, date may be fixed, Lordship. Some urgency is there, Lordship.
Okay. Short date, right?
Short date.
All right.
48. 18 June.
18 June, okay.
Yes, I'm appearing for the respondent number 2.
All parties are represented. List this matter on 18 June.
So here Lordship has seen the other documents. Now your Lordship may kindly see that page 62 is the final order passed by the additional district magistrate.
Yes.
That 1, 2, 3, 4, 5. 5th line, Lordship. That first party submitted and exhibited 2 registered purchase deeds number insurance of 1956 and 64 as Exhibit 1 and Exhibit 2. All the PW and PW, all the PW1 and PW2 and PW3 stated that since purchase, the first party have been possessing and enjoying uninterruptedly over the scheduled mentioned land. The second party members with an intention to dispossess the first party from the land used to cause disturbance which arises apprehension of breach of peace and public tranquility in the locality. Hence, first party filed this case and sought relief under section 145 CRPC. Under above and also going through the case record and on perusal of evidence of PW 1, 2, 3, and Exhibit 1 and 2, I could not find any irregularity in depositions of the witnesses, and those it is no rebuttal evidence available as the case proceeded ex parte against the second party member. Considering all aspect and material on record, I am of the opinion that first party is the owner, patadar and possessor of the land mentioned in complaint petition since long. So this is the finding. The documents which were submitted along with the WS that those were not taken into consideration. And second thing, your lordship will find there is no mention about any police report that were breach of peace. And in the Sessions Court order, lordship will find page 63. Page 63 and relevant portion I am referring to page 64.
Okay. Yes, page 60.
Page 64, lordship may kindly say paragraph 3 on which grounds I have filed that revision. Number 1, your lordship will find that the learned court below erred in law as well as on facts in passing the impugn order. There is no discussion on this point. That the learned court below passed the impugn order without complying with the provision of the CRPC. Only this was discussed, lordship. That the learned magistrate failed to apply the judicious mind on the fact that the order dated chance is not legal and proper and was not in conformity with the case record and provision of CRPC. This was also not discussed in the revision, lordship. Then lordship will kindly come to the ground number 6. That the dispute is purely private one and public is not involved in the process to attract section 145 of CRPC. So this is the very vital question which ought to have been discussed by the revision, in the revision lordship. But if your lordship peruse the entire order, your lordship will not find any line to discuss this issue, lordship. Because my whole case is that. And ground number 5, your lordship will find that the preliminary order was passed without calling the police report. So these two grounds, 6, 7, 1.
I'll consider all the grounds.
Lordship. And on this aspect, lordship, I am relying on
Yes, yes.
first judgment, lordship may kindly see that Usman Ali Soikia, that paragraph 24 and 25.
Okay.
Paragraph 24. In a proceeding under section 145 of the Code of Criminal Procedure 1973, the magistrate has to find out as to whether a party has been forcefully and wrongfully dispossessed within 2 months next before the date on which the report of a police officer or other information has been received by the magistrate. Here your lordship will find that in the complaint he says trying to dispossess. And in the final order also there is nothing on record to show any police report was obtained that he was dispossessed from disputed land.
Trying to dispossess is in apprehension of breach of
That is
peace.
no, that is not the apprehension of breach of peace. Because I am coming to that breach of peace also with Supreme Court judgment. I will try to satisfy your lordship.
Okay.
However, in the instant case, in the complaint filed by the police itself, it has been categorically stated by the respondent themselves that the respondent number 1 and his 3 sons took possession of the disputed land in the year 1972 itself. And they have paid for recovery of the said possession by filing the complaint to the Baihata police station as the suit filed by the petitioner has been dismissed by the first appellate court. From the above facts, it is clear that though there is a dispute between the respondents and the petitioners as regard the 2 lessons of land is concerned, however, this dispute appears to be a private dispute between 2 parties and there is nothing on record to show that it has disturbed the law and order or has occasioned breach of peace in the locality. An appropriate forum for the respondent for getting relief is the civil court of competent jurisdiction, and not by invoking jurisdiction of the executive magistrate's court under section 145 of the Code of Criminal Procedure. And similar to my case, Lordship, he has not approached the civil court. Without that, he has approached the district magistrate. And now, Lordship, may kindly turn to Jasmine Rahman's case, that is 2008 Criminal Law Journal 892. Oh, Lordship, I'm sorry, I have given another copy, Lordship. Jasmine Rahman's case, Lordship.
Okay, yes.
The paragraph 19 and 20.
Yes.
In the present case, the very existence of jurisdiction by the learned magistrate under subsection 1 of section 145 was challenged before the learned session judge. So I have also pointed out before Lordship that it was stated before learned session judge that it was private dispute between two parties. Learned session judge, the power given to an executive magistrate under subsection 1 of section 145 is a power which cannot be exercised arbitrarily, and when the conditions precedent for passing such an order does not exist in a given case, in order to enable an executive magistrate to assume jurisdiction under subsection 1 of section 145, necessarily it is that there is a dispute with regard to any land, water, or boundaries thereof, and the dispute must be such which is likely to cause breach of peace. This apprehension of breach of peace is one of the conditions precedent for assumption of jurisdiction under subsection 1 of section 145. The breach of peace, which subsection 1 of section 145 envisages, is not breach of peace between two parties. The dispute must be such which involves people in general. In other words, a private dispute is not amenable to the jurisdiction of exercise of jurisdiction under subsection 1 of section 145 unless such a dispute affects the even tempo of life of the people in the given locality. He even in fact reported the matter to elderly persons who did not even take care of that.
Yes.
Paragraph 20. Logically, therefore, when a order is made under subsection 1 of section 145 without the conditions precedent for exercise of such jurisdiction being present, the passing of the order drawing the proceeding would be tantamount to assumption of jurisdiction wherein no jurisdiction exists. That is my case, Lordship. When we need to remember that when an order substantially affects the right of the parties, such an order cannot be registered as an interview. So this part I'm not reading. That is not our case, Lordship. And then your Lordship may kindly see another that criminal 1991 Criminal Law Journal,
Yes.
paragraph 4 and 5.
Okay.
1769 page. 1769, paragraph 4 and 5. Paragraph 4. The scope and ambit of this section 145 CRPC come up for discussion before this court, and I may refer to the decision of this court speaking through the Honorable Justice Lahiri. His Lordship's then was, in Maqbul Hussain so-and-so, I am tempted to quote in full the first para of the observation of his Lordship, which runs as follows. It is difficult to obtain an order of injunction in a civil suit because the party is bound to satisfy the court that there is a prima facie case. The balance of convenience tilts in his favor, and also to satisfy the court that if injunction is refused, the applicant shall suffer irreparable injury. So many hurdles are to be crossed before obtaining an order of injunction. An order of injunction or prohibitory order takes away certain rights of the party injuncted. It is indeed difficult to obtain an injunction, but just throw a petition and assert that there is apprehension of breach of peace in respect of the possession of an immovable property. Claim for drawing up a proceeding ascertaining right to possess the property. A proceeding is readily drawn up under section 145 Criminal Procedure Code. The proceeding is initiated no matter whether it is private dispute between the parties or it is a dispute which necessitates drawal of the proceeding for the maintenance of public order and tranquility. Paragraph 5. It was further observed in the above case that section 145 clearly states that to assume jurisdiction, the magistrate must be satisfied that the dispute is likely to cause a breach of peace, and it is not a breach of mental peace of the parties, but apprehension breach of peace in the locality. Ordinarily, a person disposes of property must sue for recovery of specific immovable property under section 5 and 6 of Specific Relief Act. If there is a threat to dispossess him, he should institute a suit to obtain injunction. The court further held these are forum for establishing the rights of the litigants, and the proceeding under section 145 CRPC is therefore an extraordinary provision to grant extraordinary relief when there is likelihood of breach of peace in the locality. It was laid down that private dispute between two persons, which does not disturb law and order or occasion breach of peace in the locality, the forum for getting relief is civil court of the competent jurisdiction. I am in respectful agreement with the observation and law laid down in the above discussion, and I do not see any reason to take a different view. So that is the case. And another Supreme Court judgment I am relying on, Lordship, that 2004 1 SCC, Lordship.
Okay.
Santi Kumar Devi printout I have given, Lordship. That paragraph 10, Lordship may kindly see. Possession is 9 points in law. Our purpose of the enforcement of law is to maintain peace and order in society. The disputes relating to property should be settled in a civilized manner by having recourse to law and not by taking the law in own hands by members of society. A dispute relating to any land, etc., as defined in section 2 of section 145, having arisen, causing a likelihood of a breach of peace. Section 145 of the code authorizes the executive magistrate to take cognizance of the dispute and settle the same by holding an inquiry into possession as distinguished from right to possession or title. The proceedings under section 145, 146 of the code have been held to be quasi-civil, quasi-criminal in nature, or an speedy and summary remedy so as to prevent a breach of peace by submitting the dispute to the executive magistrate for resolution as between the parties disputing the question of possession over the property. The magistrate, having taken cognizance of the dispute, would confine himself to ascertaining which of the disputing parties was in possession by referring to the date of the preliminary order or within 2 months next before the said date, as referred to in the proviso to subsection 4 of section 145, and maintain the status quo as to possession until the entitlement of possession was determined by a court having competence to enter into adjudication of civil rights, which an executive magistrate cannot. The executive magistrate would not take cognizance of the dispute if it is referable only to ownership or right to possession and is not possession simpliciter. So here this is not a case of possession simpliciter. Here right is also involved, Lordship. The executive magistrate would not take cognizance of the dispute if it is referable only to ownership or right to possession and is not over possession simpliciter. So also the executive magistrate would refuse to interfere if there is no likelihood of breach of peace or if the likelihood of breach of peace though existed at a previous point of time. So what I am pointing out is that when he filed the complaint, he mentioned that there is chance of breach of peace. The order, that complaint was filed in the year 2014. The final order was passed 2020. Where is that satisfaction that yes, now there is chance? Lordship may kindly see
Complaint filed in
2014,
final order filed in
2020, after 6 years. So this line covers my case, Lordship. So if there is no likelihood of breach of peace or if the likelihood of breach of peace though existed at a previous point of time had ceased to exist by the time he was called upon to pronounce the final order so far as he was concerned. Because when the order was withdrawn, it was apparent that the order reflects that there was no chance of breach of peace. It was there. So what subsequent material he has received, whether any police report or anything else. And the main thing, Lordship, that the dispute was between two persons. It was not about two groups. And when two persons are concerned, then, Lordship, that 145 jurisdiction does not have. Magistrate have do not jurisdiction under section 145, Lordship. And apart from that, Lordship, one more judgment I am referring, Lordship, that I will give a copy, Lordship, that I could not have. GLR 2014, GLR 2014, Volume 3, 552.
Okay.
Here it was held that 145 proceedings should, Lordship, come to a conclusion after 1 year, Lordship. That if breach of peace, that part.
6 years is
Too long. That is what I'm.
that is what I was about to say, where it must go up to 2 months.
2 months.
Why
Yeah.
it took 6 years?
And in
That
fact,
is
it is the today that in 2025, it is the 11th year. And another judgment, Lordship, I am relying on AIR 1981 SC 1400. It is on the point of that negligence of advocate client should not suffer, Lordship. Because ultimately he relied he relied on his counsel, he submitted WS,
That's a
and
very
whether
good
he
point.
subsequently cross-examined or not.
GLR এইকেইটা তুমি উলিয়াই দিবাচোন দেই পাৰিলে SCC পৰা GLR মই লিখি দিছো এইখিনি লৈ যোৱা GLR 2014. What is the party's name?
That party's name I could not write, Lordship. And,
Okay, it's okay. Yes, she'll find out.
Lordship.
1981 SC 1400. All right.
May I submit? Well, as far as the proposition,
You want
Yes,
to
submit, I will reply, Lordship, if required.
as far as the propositions of law are concerned, my lord, which my learned friend has submitted, there is no argument. I cannot argue against the law. It is a fact, my lord, when it is a private dispute between two parties, forum is the civil court. Executive magistrate jurisdiction only comes when there is an apprehension of breach of peace. Now, whether there was an apprehension of breach of peace, that is the issue to be decided. Now, one thing at the end he has pointed out, this should have been done in 2 years. Now it's the 11th year or the 15th year going. Issue started in 2014. First we get an attachment order. 2 months they get it
Continue
vacated.
till 20.
Vacated. Then they stop appearing. Now my lord will see this delay is attributable to me or delay is attributable to him, my lord. And 2020 this order gets, now they again go for revision. In the revision, another 4 years goes. Then they come to the High Court. So when it is argued that an 11-year period has passed, whether that delay is attributable to me or to him, that is the first. Now, my lord, first point, my lord, whether there was an apprehension of breach of peace or not. I will come back to the complaint, my lord. Page 14, it starts, my lord. Because as far as the civil rights of the parties are concerned, my lord, we have produced sale deeds, they have produced sale deeds. That is not an issue which is to be examined by the executive magistrate. Only issue is breach of peace. Now, what it is that I have alleged, my lord. Page 15 it starts, and relevant portion I will start from, my lord.
Next page, page 16.
Okay.
But in the morning, that is on 15/6/2014, when the first party went to his land for tilling it, the second parties, armed with dao, lathi, spear, etc., resisted the first party from tilling the land with a threat that they would kill him. Though the helpless first party raised the matter with the local elders for a বিচার, the second parties are still trying to dispossess the first party from his below scheduled land by uprooting the boundary walls of their land and affixing the same on the land of the first party. The second parties have also been declaring before others that if the first party goes to the below scheduled land, they will kill him. Now, whether, my lord, this allegation is a private dispute between two parties, or this is an allegation which has a direct connection with the law and order, the same judgment which my learned friend has submitted, what does the judgment say? What does the Honorable Apex Court say? That if it is only a matter of private disputes pertaining to ownership or possession between two parties, civil court is the forum. This allegation, my lord, of threatening to uproot the boundary walls, affixing the same on the land of the first party, declaring that they would kill him, arming themselves with dao, lathi, spear, etc., resisting the first party from tilling the land. This is not a private dispute between two parties, my lord. This is an exact act which comes within the definition of a breach of peace, because this act, if continues, this will lead to breach of peace, my lord. And unlike 107, here, my lord, the language of 145 is very clear. If your lordship will kindly have 145. CRPC.
Yes.
145, subsection 1 of CR.
Yes, yes.
Yes. May I read, my lord? Whenever an executive magistrate is satisfied from a report of a police officer or upon other information that a dispute is likely to cause a breach of the peace exists concerning any land or water or the boundaries thereof within his local jurisdiction, my lord. So, first requirement is that there has to be a dispute pertaining to land or water, my lord. That dispute is existing here between both of us, because both of us are claiming the same land, my lord. Now, in respect of that same land, if there is a dispute which is likely to cause breach of peace, now coming armed with dao, lathis, and spears and preventing the parties from killing the land or telling the people that we are going to kill the persons, my lord, that comes within, is squarely covered by this. Now, one point which my learned friend has been submitting is that there was no police report. Now, this section itself makes it very clear that when the executive magistrate is satisfied from a report of a police officer or upon other information. So it is not just a police report. Police report is one component. If there is other information available, on the basis of other information also, this order can be passed, my lord. So it is not necessary that it always has to be supported by a police report. Now, coming to the orders, my lord, the three orders. The first order, your lordship, my learned friend has already read, but I'll read the whole orders because that is more important, my lord. Page 24. Page 24, my lord.
Page 24.
24. The first order where the attachment was done, my lord. May I read, my lord? CR is taken up in my file. Peruse the complaint petition with affidavit along with Xerox copy of land documents filed by one Aftabuddin Majumdar. This is the respondent. And two others, so and so, so and so. Heard the learned lawyer for the petitioner first party. From the above, that I am satisfied that there exists dispute between the parties regarding possession of a piece of land measuring 2 bighas and 3 kathas under district Kachar. So and so, so they've given the details, my lord. As described in the complaint petition, which is a cultivating land, and the existing dispute may lead to serious apprehension of peace and public tranquility on the locality. As such, I do hereby draw up a proceeding under section 145 CRPC and ask both the parties to appear before this court on the next date fixed and submit WS to substantiate their respective claim of their possession. Further, to prevent any untoward situation, the disputed land is hereby attached under section 146 CRPC, restraining both the parties. It's not like only I was restrained or he was restrained. The executive magistrate feels an apprehension because there is a specific allegation of threat of apprehension which is there in the complaint. So he is not only passing an order to his prejudice. The order
Just a moment, no. LCR asen nahi, yeah?
LCR is there.
Both the cases, no?
The other is only the revision, my lord. Perhaps the important one is the
main proceeding line.
Scan number হয়ে যাবে LCR হবে okay it's okay.
So my lord, what the executive magistrate does is he restrains both of us. He attaches the land and he restrains both of us, and neither of us can enter the land. Now this order your lordship will see was passed-
LCR আছে না এই কেসটা okay.
So this order was passed on 18/6/2014, my lord. Now he appears, he files his WS, my lord, WS is already read out, so I'm not reading that. Now, on 21/7/14, 1 month later, my lord, the second order is passed whereby this attachment order is withdrawn. Now grounds here also, my lord, we'll see. First paragraph, my lord, he has also read, my lord. So second paragraph, on perusal of the relevant papers, documents and on hearing both the parties and their engaged lawyer, who have neither in writing nor verbally stated about the apprehension of breach of peace and peace over the matter at present, and since the DL is cultivable land and period of cultivation is passing out, so I am of the concerned opinion to withdraw the attachment order dated so and so forthwith, next date specified on 11/9/2014 for filing WS by the parties concerned without fail. So what has happened on the next date, my lord? On already, because this is a quasi-civil nature, I have filed a complaint. The rule of pleadings will come in. My complaint is there. His pleading will also come in the form of a WS. But additional DM has still gone way ahead, one step ahead, and said that on that day, since I have not raised the issue of breach of peace, so he is vacating the attachment order, and because also the land is cultivable land. So that is done. We have not assailed that. They have not assailed that. That goes. Now the proceeding starts. He files WS. After filing WS, now he does not appear. So my lord, now when I have filed a complaint, notice has been served to him. He has filed WS. He produces certain documents. Now it is also his duty to come and adduce evidence, because I have come and adduced the evidence of 3 witnesses. I have also exhibited 2 documents. Now, when these documents have been exhibited and oral evidence has been, my lord, evidence has been given by 3 witnesses, unless and until those evidences are controverted by them, that is a principle, my lord, that unless and until any claim is controverted by the other parties, that claim will be accepted by the court. Not only did they not adduce any evidence, my witnesses were not cross-examined. The documents which were exhibited by me, we were not confronted with those. So when I have done my due diligence, my part, I have adduced my evidence and brought my documents, and they do not do it. Now they are coming and saying that my documents which were exhibited with WS or which were attached with WS were not considered. Why should they be considered? Court, because an executive magistrate is still a court, my lord. When he's passing an order, he will pass an order on the basis of the evidence. Pleadings is only for the part of deciding the issues. So when there is no evidence from their end, and there is uncontroverted evidence from our end, my lord. So when those evidences have been considered and this order has been passed, so where is the perversity, my lord? And now the first impugned order. So these documents they have brought in now. Your lordship will not examine these documents in 482 because these were never part of the evidence. In 482, these documents, their validity, their contents cannot be examined. Now page 62, my lord. The final order of the executive magistrate.
Yes.
Peruse today is the date fixed for order. Peruse the entire case record. First party, that is me, my lord. I am present and submitted Hazira. Second party absent without any steps. Now next line, your lordship will kindly see.
Yes, yes.
On perusal of the case record, it reveals that due to non-appearance of the second party for many consecutive dates, the case proceeded ex parte against the second party. Now, today when it is come and it has been contended that this is because of an error of the lawyer, a party should not suffer, then this whole concept of ex parte proceedings, my lord, some person comes and gives evidence. In a case, the lawyer does not properly cross-examine, then appeal, they will come and revision, they will come and say, my lawyer did not, it was because of a mistake of my lawyer. Who has picked up the lawyer, my lord? It is that they are being defended by a pleader or lawyer of their choice, not a government appointed lawyer. So their lawyer, they have not appeared. And is it only the responsibility of the lawyer to go and appear in the case, my lord? It is also their responsibility. Now, can it be so easily, can the fault be so easily fixed on the lawyer? Have they gone and filed any complaint with the bar council against the lawyer? That because of your error, I have suffered.
And was it only the responsibility of the lawyer? First party was present, I was present, I filed Hazira. What was stopping them to go to? They did not appear for multiple days. Court waited, eventually proceeded ex parte. And now an ex parte order has been passed based on my evidence, without their evidence. Now it is being contended that it was the fault of the lawyer, so party should not be served. What was the context of the judgment, my lord, where this order was passed, my lord? That will definitely be not in the context of an ex parte order, my lord. And what is the finding of the magistrate, my lord? Ex parte evidence of first party is examined as PW1, two others as PW2 and PW3 is also examined. All their statements are supported with affidavit. PW1, PW2 and PW3 in their statements, it is examination in chief supported with affidavit, deposed that the first party is the owner and possessor of the land as mentioned in the complaint petition by way of purchase by himself as well as the father of the first party. First party submitted and exhibited two registered purchase deeds, white number so and so, so and so, so and so. All the PW1, 2 and PW3 stated that since first purchase, the first party have been possessing and enjoying uninterruptedly over the scheduled mentioned land. Now, next line, my lord. The second party members with an intent to dispossess the first party from the land used to cause disturbance which arises apprehension of breach and public tranquility in the locality. So where is the question of there being no apprehension and no application of mind by the magistrate? I have adduced evidence. My evidence says that the second party was trying to dispossess me. So apprehension is, I have made out the case of apprehension, my lord. And since my evidences are uncontroverted, so this remains, my lord. This does not go away in any manner. So they cannot come and say that this is not there, my lord. And this, again, I have submitted, my lord, section does not mandate a police report. Police report is only one component. Any other information. So when I have adduced evidence, I have filed a complaint, I have adduced evidence where I have specifically brought in this allegation, my lord. They tried to kill me and they tried to dispossess me and they resisted me from killing the land. This is covered by the second part of section 145. So this will also come under the ambit of breach of peace, my lord. So under above and also going to the case record and on perusal of the evidence of PW1, PW2 and PW3 and exhibit 1 and exhibit 2, I could not find any irregularity in the deposition of the witnesses and there is no rebuttal evidence. So that part has also been discussed. There is no rebuttal evidence available as the case proceeded ex parte against the second party member. Considering all aspects and materials on record, I am of the opinion that the first party is the owner, patadar and possessor of the land mentioned in the complaint petition since long. So I hereby declare possession of the land in favor of the first party. He is not declaring my ownership. He is only giving that I am the possessor. So OC Sonai police station is directed to keep the second party member from the DL and make sure that the first party can enjoy peaceful possession of the land mentioned in the schedule of the complaint petition. So the effective order which has been passed is that the OC has been directed to ensure that the second party does not disturb my possession. So there is no perversity, my lord. This is squarely within the ambit of 145. Now this order was ex parte order was passed. They did not try to get this ex parte order vacated. They filed a revision petition on merit. Their grounds, my learned friend has read that the learned court below erred in law as well as on facts and passing. That's a general order, my lord, general ground, my lord. Now, one of the grounds which they have relied upon, two grounds, my lord, which my learned friend read. One is ground 6, that the dispute is purely private and public is not involved in the process to attack 145 of CRPC. This is not a purely private dispute, my lord, because a component of use of force is there, use of apprehension of dispossession is there, apprehension of attempt to kill is also there, man. And 145 does not essentially say that the larger interest of the public has to be there. What the magistrate has to see is that whether there is an apprehension of breach of peace, only that part. That apprehension we have made out and it is not been disputed. Second part is that second ground is preliminary order was passed without calling police report. That is not mandatory. Now in the revision, now this they have mentioned these 6 grounds. The learned court, additional session judge, discussed one ground, para 4 your lordship will see. The connected LCR was called for in this context and it was duly perused and notice was issued upon the OP who appeared to the advocate, but the appointed counsel failed to appear at the time of hearing and on subsequent day. The learned counsel representing the revisionists have been heard who submitted that the OP filed evidence in chief in form of affidavit, which is beyond the scope of section 145 of CRPC, and the court below relied on such affidavit and not examined the witness. Now, next page, my lord. the discussion starts after reproducing the section. From the above provision of law, it may be mentioned in this context that section 145 of the CRPC empowers the magistrate to make an order in writing, stating the grounds of his being so satisfied, either from a report of the police officer or upon other information, that a dispute likely to cause a breach of peace exists concerning any land within his local jurisdiction, and requiring the parties concerned to attend his court and to submit WS in support of their respective claims. And no hard and fast rule can be laid down as to the sufficiency of materials for the satisfaction of the magistrate, and it must be construed from the facts and circumstances of a particular case. After hearing, the parties can pass final order declaring possession in favor of the party who was in possession 2 months prior to the dispute. On perusal of the impugn order, it is so and so, and also the connected case record, it is found that the learned court below declared the possession in favor of the OP. One issue regarding the 2 months issue is there, because this case was protected, not because of me, because they stopped appearing in the case and this case had to proceed ex parte and I had to adduce evidence. Now, the learned court below based its finding on the evidence as adduced by the witnesses of the OP. The main challenge that has been made in this revision with regards to the fact that the OP as first party filed evidence in chief in form of affidavit, which is beyond the scope of section 145 of CRPC, and the court below relied on such evidence and not examined the witnesses. So, though they took out 6 points, my lord, here also your lordship will notice he has pointed out 6 points. He has effectively argued on 2. It's public and the other was. Here they made 6 points, they argued only on 1 point, my lord. So I'm sure the learned court otherwise would not reflect that. The learned additional section thus reflects that they have only raised one issue, that this evidence was given on affidavit. So this has also been discussed. It is correct that there is no procedure that has been prescribed in CRPC except 295 of CRPC that evidence may be filed in form of affidavit. But the proceeding under section 145 of CRPC is quasi-civil one, and there is no bar to receive the evidence in form of affidavit. It has been held in Rudra Singh versus Bimla Devi, AIR so and so, that magistrate can come to the conclusion on the basis of evidence in affidavit as submitted by the party. This was their main contention, that evidence on affidavit cannot be filed. This is one judgment which the learned additional session judges relied upon. I have one judgment from this honorable court also. But today they have not raised this point, but I am still submitting that in 145 proceeding, there is absolutely no bar in giving evidence on affidavit. So these are the facts of the case, my lord. Now they are proceeding before magistrate. There's an order. Revision has been done. Revisional court has upheld that order. Now they have come before this honorable court as a court of third instance, my lord, under 482. And your lordship knows that a court of third instance is not going to reanalyze and reappreciate the evidence. There has to be perversity apparent on the face of the record. My lord, at least, my lord, in my respectful submission, there is absolutely no perversity on the face of the record. Whatever judgment says relied upon, my lord, there is no dispute on the judgment. That is the law. But unfortunately, those judgments are not applicable in the facts of this case. Those were contested cases. Both parties adduced their evidences, and the Honorable Supreme Court or the High Court, my lord, came to a finding that this was a dispute purely of private nature, civil in nature. This is not a case.
So this is the 11th year now.
Yes.
11th year.
11th year now.
So possession declared in their favor, but are you prejudiced?
I am the owner of that land. He, without going to civil court,
He is possessing the land.
No, I am in possession. I am having those documents. He is therefore not aggrieved. He has not gone into civil court. He is not going there. He knows that he cannot prove those documents. Therefore, he is taking this report.
Possession has been declared. He has no lawful right over the land.
No, actual right.
So what is the point of pursuing this?
No, even if
I see no point.
No, if I handed over because my house is there.
You are already in possession.
No, now this order has been directed to hand over that land to him.
No, my lord will see this.
Yes,
point.
that is the point. Lordship, may I kindly see that page 62. Page 62. Last paragraph. OC Sonai Police Station is directed to keep the second party member from the disputed land to make sure that the first party can enjoy the peaceful possession of the land mentioned in the schedule of the complaint.
All right.
And before that paragraph also declare possession of the first party.
Not handed over to make sure
not-
you are kept away.
No, I will be evicted. Because of that, Lordship, I have to obtain a stay order from this honorable court. And
You are
apart from
already on stay.
yes, I already on stay. And apart from that, Lordship, if your Lordships
Just one more point. One, he is saying that he is the owner of the land. He has brought in his evidence, he has brought sale deeds. Oh, sorry, in his WS, he has brought sale deeds. He has not produced those, given those sale deeds in evidence. we have produced two sale deeds, my lord. One showing
Yes,
that I
yes.
have purchased the land, we have exhibited those in the before the magistrate. Those have not been uncontroverted. It is our claim that we are the owner. We have been in possession. The executive magistrate has found that we are in possession. They have not been able to show that we are not in possession. It is not the case that he is the owner. It is our case that we are the owner and we are the possessor. And they, in our complaint also, it was specifically contended that they are trying to dispossess us. So we were already in possession. The executive magistrate only declared that our possession be protected. Now, if he claims he is the owner, he wants recovery of possession, it is he who has to go to the civil court. I am already in possession. I have the two sale deeds. I am in possession. Why should I go to the civil court? It is he who says he claims that he is the owner because he has those deeds. I am in possession. So if he wants the declaration of right, title, and interest, and if he wants the recovery of possession, it is for him to go to the civil court, adduce evidence, and establish that he is the owner and possessor. 145 by way of 145
You
proceeding.
to the civil magistrate.
Because we are already in possession, my lord. We claim ownership. We claim we are already in possession. We win because when they try to dispossess us.
Then
So
why
we
did
are
you
not
go to the
required to go
civil
to the
court?
civil because my lord, we are not required to go to the civil court when we are already the owner and already the possessor. When they try to dispossess us, then our proceeding and they try to use force. Then we go to the magistrate only to seek protection of our possession. That is the only limited prayer. Now, if they want ownership, if they want recovery of possession, they can go to the civil court. Nobody is stopping them, my lord. Now, after 11 years, let them go and to civil court. Our possession has already been protected. How can this now in a 145 or a 482 proceeding? How
So
can
where's your remedy now? Your
ultimately,
documents have not been exhibited. How will you bring it
So
in?
Lordship, may I kindly say one aspect, just page 32 for a moment.
See, no, you see, you have not exhibited the document in the
No,
magistrate
that I
court.
admit. Lordship, may I kindly appreciate one aspect that because of fault of advocate, he should not suffer. That is my whole case. Because I have even, Lordship, if you see page 32, first paragraph, I have exhibited all the, presented all the documents to my counsel and he submitted before the additional district magistrate. If he subsequently do not exhibit or suggest me, Lordship, I cannot go beyond that, Lordship. So Lordship, my second subsequent prayer before Lordship is that both the matters may be remanded back on this aspect and he may be given one opportunity because your Lordship will find there I have stated that I have purchased the land. And there is not a single document your Lordship will find that he has said that no, these documents are not correct. It is in the order itself, page 32. Lordship may kindly see.
Can be remanded.
No, my lord. Because
Otherwise also that I have taken the plea that it is a private dispute. Let them ascertain from the from record that whether it was a private dispute or there is some sort of breach of peace. Everything will be clear, Lordship. Both parties will be satisfied, Lordship. Because ultimately what they want without going to civil court, by what I have read just before your Lordship, that 140 just throw a petition and get the order. That is what they are doing. That cannot be encouraged, Lordship. Because I have purchased the land, I have right to enjoy my land. And because just they are throwing one petition before the district magistrate, I will lose my every right, Lordship, to enjoy the land. That cannot be, Lordship.
I have strong objection to this, throwing a petition at the district magistrate. We have invoked a statutory provision of law. Opportunity was given to them. It's not like everything was passed in their absence. Notice was served. They appeared. So when he says that we threw a petition at the district magistrate did not take my possession and directly pass their order. District magistrate issued notice. They appeared. They filed WS. Now they falter for 6 years. And now they say that we just threw a petition in the district magistrate and got an order. This is a statutory provision in the statute. We invoke that provision. Fair opportunity of hearing was given to them. After being given the fair opportunity of hearing, if they do not avail that right, now, in fact, they themselves have been saying that this has been going on for 11 years or 14 years. Now they are claiming that let the matter be remanded back. Why should the matter be remanded back now when the court has given a finding after giving them adequate opportunity? And it is not a case, my lord, where only the advocate has to go. Why did he not go? How can the entire blame be put on the advocate, my lord? Is there anything to show that this fault was because of the advocate? Is there any complaint to the bar council against that advocate? Is then even the name of the advocate been given in their petition that because of the fault of this, any pleadings in this petition that because of the fault of Mr. X, I suffered and we have initiated these proceedings? For well, if you even forget about the proceedings, it's not even mentioned who is that advocate because of whose fault he has suffered. Now all of a sudden it is very convenient to put the blame on some anonymous advocate because of his fault. He himself could have gone. I was going on every day. Why could he not go? So, my lord, this is not a case of remanding back. If he has any grievance, those grievance can be ventilated before a civil court. He claims he has deeds. I claim I have deeds. Let him go and file a suit because I am in possession now. I claim to be the owner. He has to recover possession from me. That cannot be done because I was the complainant in the 145. He did not file any 145 case. So how can he recover possession now in this 482 in my complaint? In my complaint, my possession was protected. How can he recover his possession? He claims he had possession. How can he recover his possession from my complaint or in this 482 matter? He has to go to the civil court. There is no other remedy.
No, the period of limitation is also over.
And in the complaint, he says trying to dispossess, and Lordship will find that it was directed to restore the possession. Then how that can be? And one aspect, Lordship may kindly say page 32 for a moment. Page 32. That first paragraph I have skipped, but now it has to be read. Lordship, paragraph 32, page 32, first paragraph. If any for documents is false, that the deeds are false, he could have lodged an FIR. He never did. Even he has not rebutted that on the same date. Your Lordship will not find any rebuttal argument was there on that date. That is, those are not genuine or something else. In his presence, this order was passed.
So he could have evidence on that point.
Lordship, may I kindly read that paragraph I'm reading. 21/7/2014. Both parties have appeared along with their engaged lawyer, learned lawyer, seen the prayer petition filed by first party and also seen the prayer petition and other relevant papers submitted by the second party. So other relevant papers. Heard both sides. The learned lawyer for first party has paid for specifying another date for file WS by his client. The second party engaged learned lawyer has submitted that Muhammad Azizur Rahman Baruya, that is the vendor of the first party, of the second party member Muhammad Alam Hussain Baruya had purchased the disputed land from the first party. Complainant and others by executing registered sale deed white number so and so in the year 1993. And the second party had purchased the disputed land from aforesaid Muhammad Azizur Rahman Baruya in the year 1993. Those documents I have shown to your Lordship. And since then, the second party has been cultivating the land. The learned lawyer for the second party has also submitted that the period of cultivation of disputed land is passing out, and hence on the basis of the relevant documents and the attachment order dated so and so is required to be vacated. So all those documents were produced. He had the knowledge. If there is something in the record that those documents were not genuine, he has submitted, then Lordship, it is a different aspect. He has not said. It is in his knowledge that on the basis of that I have paid for withdrawing the attachment order. Therefore, he has not challenged these orders before the higher forum. And when it is also on my fault. That is
See,
not
those
I am disputing.
documents, the soilies have been discussed in the order. We can take into consideration.
Yes, it is discussed here, but in the final order, it has not been mentioned.
But it has
This
been
is an
taken into
interim order, ma'am.
consideration in this order. We can
I know.
take into
First order was passed where land was attached and both of us were restrained. Both he and I were restrained. This time he comes and he gives these documents. These are only pleadings, my lord. These documents have not been proved. And what is the reason why the court has withdrawn the attachment order? Because it is cultivation season, land is cultivable land, and because on that day I did not further say that there was a possibility of breach of peace. Whereas in my complaint it is already there. So these are pleadings, these are photocopies of documents, my lord. If these documents had been adduced in evidence, then it would have been a different matter. When evidence is not there on photocopies, my lord, with pleadings, pleadings will not decide the case, my lord. Evidence will, in fact, 145 says, magistrate will take evidence and then decide the case.
All right.
That is where I am praying, Lordship, that in that case, matter may be remanded, because ultimate purpose of trial or everything is to find out the truth. If I have been given, if your Lordship give me one more time, that truth will come out. Only that much, because mere technicality should not suffer. The truth should not suffer, Lordship. Only that much. Because whatever is there, that will come out.
Not a question of technicality.
And because session judge also did not consider that aspect, that private dispute. Those aspects they will consider and pass an appropriate order.
Your lordship can also decide that part. Matter is before your lordship. Your lordship can also decide this part. Whether this was actually from our pleadings and our evidence, because record is there, my lord, our evidence is also there, my lord. Whether our evidence, because this is uncontroverted. So whether from our evidence, if there is no apprehension of breach of peace, your lordship may very well vacate the order, my lord. But if since we have given uncontroverted evidence, making specific allegations of where they are trying to dispossess us, this is not a question of mere technicalities. Opportunities were given and an ex parte order does not get vacated before a court of third instance citing mere technicalities, my lord. Opportunities were given, procedure is always there. If there's an ex parte order, that can always.
You have dispute over the entire land, not boundary dispute.
No, my lord. Dispute over the entire land. So a civil court is the best forum to decide this. Not before in a 482 proceeding, man. That too with only photocopies of documents which were never exhibited. That is my humble submission.
And although Lordship, I have submitted those judgments, Lordship, only one aspect, Lordship, may only consider that one sentence I'm quoting, Lordship, and from live law where I have read that the Honorable Justice said, Lordship, that justice can be banned for truth, but for that cannot be vice versa. So here, Lordship, I'm only for truth, Lordship. I'm praying before Lordship that considering all aspects, if your Lordship sends back the matter, then ultimately the truth will survive.
You see
Because if it is
procrastination, you see.
no, if you
Years and I'll send it back and then it's a matter of 145 which has to be disposed. of
otherwise
6 months.
also I have submitted that this is dispute between two parties, and even after withdrawal of that attachment order, nothing happened.
He
Because
was never
ultimate-
there. How would he know? Then nothing happened, my lord.
Because that would have been in
Not
record.
very convinced that dispute between two parties only. Not very convinced.
Because ultimately, your Lordship, that in the complaint also, your Lordship will find that threatening to him. Just your Lordship, may kindly see that aspect. Just one line I am reading, Lordship, that page 16, Lordship will find. Second party have also been declaring before the others that if first party goes to the below scheduled land, they will kill him.
That is only one
It is
part.
the one-
The other two lines before that, my lord. He's only reading one line. The other two lines before
Threatening
that.
is to one person.
Before that, because threatening one person may be a criminal offense, my lord. But main issue is that we are coming armed with dows and restraining me from tilling my land. That is the main crux, not the threatened part, my lord.
And the judgment which I have cited that clearly says, Lordship, that if it is dispute between two parties and there is no other material. And my prayer was that matters may be remanded, but he may be given one more opportunity because the judgment which I have cited,
See,
there your Lordship will.
short notice, I could have remanded back.
Lordship.
Remanding this matter now at this stage.
Because otherwise he will suffer, Lordship. That is the difficulty.
He can always go to the sigma. I don't understand
No,
this.
because
But see now
obtaining,
period of limitation is over for him.
yes,
How can he go to the civil court now?
My lord, his period of limitation will be 12 years. Now, if he is claiming, he claims that he is the owner, he is the possessor. When was this possession handed over? According to him, let us assume, my lord, his case. His case was that in 2020, he was in possession. 2020, because of this order, he loses possession. So this is 25, my lord. His limitation is intact.
No, that if he goes from this order, it's okay.
Yes, my lord. No, because he is claiming.
But he didn't go, he came here.
No, my lord.
He has
He-
come here.
What I have been trying to understand, because what he has been claiming, because that was his submission that he was the owner, he was the possessor. But because of this order, because 146 order that got vacated in 2014 itself,
But he didn't prefer any against the order where he lost his possession.
my lord. In 2020, if he
approached
loses,
this court.
in 2020, if he loses possession, according to him, then his limitation is still intact, my lord.
no, that possession he has not taken. So it is still in the petitioner's possession.
So if it is in his
So
possession,
it
then
is my position, because now, Lordship, if possession goes, Lordship, I have read from the Supreme Court judgment, the possession is the 9 out of 10 point. Lordship. If possession goes, I will lose everything, Lordship.
So if he
That
has,
is the case. That is why I am praying for that matter may be remanded back. The truth will come out. Only that much.
if he has possession,
Because ultimately,
then he will seek only, my lord, declaration of right, title and interest.
But we have heard so much. Then you give me some reason to remand it after so many years.
because Lordship,
And
that,
then you rebut it, we'll bring it up again.
yes,
And
that,
then we'll pass an order there.
yes, that order page 32, Lordship, I have shown to your Lordship that documents were there. And absence of counsel, that
No,
party
give
should
me
not
a
suffer, Lordship.
But you see, there are many orders, many
Lord-
judgments.
Lordship,
Under section 142, everything has to be disposed within 1 year.
1 year.
Then again, attachment order, goes up only to 2 months.
Lordship.
So, maximum 6 months.
Lordship.
What is the point of remanding back this case at this juncture?
To decide whether any cause of action survive or not. Because Lordship, it is 11th year and that the judgment GLR which I have given, that it says 1 year.
So that is the law, my lord. 1 year is the law.
Yes.
But why was 14, my lord will see the chronology. 14 first
So
attachment.
when
is there.
within
Proceed.
1 year, everything has to be decided.
Decided.
It will come to the appellate forum.
No, by the additional district magistrate.
So he does not appear for, my lord, because of his delay, his procrastination, my lord, these delays caused. And one thing I'm again submitting, my lord, from what I have understood, if it is his claim that he is still in possession, then there is no question of limitation running out. Because only thing which he will seek is confirmation of possession. If he is in possession even today, even if you forget about the orders, if he is in possession today, if he has the deeds to show that he is the owner, then he will only seek declaration of right, title, and interest on the basis of the deeds, and he will seek confirmation of possession.
Yes, yes.
So if he is seeking
Yes,
confirmation,
yes,
there's no
confirmation of
limitation.
possession, yes.
So limitation has not run out. So if he has any grievance,
On confirmation, possession, remuneration will not.
not run out, because he is already in possession. That is his claim. So there is no question of limitation running out. So his grievance can be ventilated before a civil court. Now, after 11 years, no point in remanding this back, man. Let him go to the civil. The moment a civil case is filed, 145, all of proceedings becomes infructuous. All of these orders will anyway go. Let him
We'll
get his.
discuss and pass this order.
My lord.
But ultimately, your lordship has to.
I'll keep it, I'll not close it. Come back tomorrow, day after tomorrow. Monday, Tuesday, all of time will be ready. Show me some good grounds also to remand if you want remand. And you can rebut if you want to rebut.
Yeah, otherwise, I have nothing more to say. If he has something to say, I have nothing more to say.
How you have said more than enough.
That's why I have
ultimately,
nothing more to
On being in a privileged position, you have said more than enough, but even then.
But
let us come
ultimately, your
back.
lordship has to be satisfied that.
Because I want to hear you pass the order.
Right.
Instead of forgetting,
Lordship.
because this is important, because everything is running out now, running out of time. So
Lordship may issue decide that issue itself, that private dispute part. I will try to satisfy on the next date also, because.
I'll start with the dictation on that day itself.
Yes.
And then
If anything is required,
I'll
my lord,
finish
we'll-
it off. And then you help me out, this with whether I can remand it after such a long period.
That
That
judgment.
145,
But
other.
that judgment says.
I can, any other cases I can remand. Even after 20 years also I can remand.
Lordship.
Despite much
No.
of hesitancy, I can demand. But this.
But your lordship has to see that if any injustice is caused, that in that case, lordship can remand.
Yes, let's see.
That is what I'm placing with your lordship.
Yes. I don't want to forget your submissions actually. If I
Okay.
close it and then keep it for 3 months,
Lordship.
then I'll forget many
Lordship.
things.
That AR judgment which I have given.
Getting you on the spot, I'll pass the orders.
Lordship.
So that I can pass the order on spot without forgetting any point.
Even on a Friday, my lord.
Part heard, list this matter as part heard matter. Take it to the. Do you know without because I'll need time, you'll also need time. And there'll be dictation also.
Hearing date, hearing take one.